This meeting is taking place at 1110 West Washington, Suite 250 in Phoenix, Arizona. This is the 638th regular meeting of the Arizona Racing Commission on Thursday, October 8th, 2015.
Verizon, it's 10 o'clock, so we'll call this meeting to order. I guess, do we need to approve the minutes of the special meeting?
They are not on the agenda, so they will be on the November 17th agenda.
Okay. So, the first item of new business is...
Excuse me, may I do a roll call, please?
Oh, absolutely.
Okay.
Thank you, Cassie.
You're welcome. Bill Feldmeyer?
I'm still in this corner.
Okay. Ms. Tom Lawless?
Yeah, here.
Jay McClintock?
Here.
Rory Gorey?
Present.
David Heupel?
Here.
Thank you.
All right, the first item of new business is the continued notice of appeal to the Arizona Racing Commission of the Director's ruling to grant a racing license to Ron Sims. I guess a couple of things we need to clarify. One, I may have made a comment that I thought that the commission could hear this if we decided to. I didn't mean to say that we have the authority to hear it. It was just a personal opinion, so I'd like to clear that up. And I guess I have a couple of questions. First, for Director Casillas, and this is primarily for you and Director Bergen. When you guys decided not to take action on the ALJ ruling to grant Ron a license, was that because you agreed with the ruling, or was it because, I'll let you explain.
Yes, I read the ALJ's recommendation from the hearing that was conducted at OLA.
It's very difficult to hear that.
I reviewed the... Is this thing on?
Yes.
It should be. I reviewed the recommendation from the ALJ from OLA. Knowing that the ALJ, being an attorney, independent body, listened to all the facts of the case, all the evidence that was presented, and I did not disagree with his findings of fact and ultimate recommendation. And that is why I did not modify or reject that decision.
Okay, good. We have quite a quandary here, I guess, is what's right and what's wrong. Thank you both for the briefs. They were well written and very interesting, and you both made a ton of good points one way or the other. I guess another question I would have is, if Ron has a license, what does he intend to do with it? Is he going to build a racetrack? Mr. Grossman, please.
Mr. Chairman, thank you, and thank you all for the courtesy of letting us speak with you this morning. I don't know the
I'm
answer.
sorry, could you please identify yourself on the record?
Yes, thank you. I'm sorry.
Thank you.
I neglected to do so. My name is Marshall Grossman, counsel for Ron Sims.
Thank you.
Ron Sims is not a horse person. He loves horses, but he has never been in the horse business other than to the extent that he has been licensed for 15 years by this agency. The reason why he obtained his license in the first place was because he had a very substantial investment in Turf Paradise and was concerned about the continued viability of his brother Jerry having a license, given Jerry's difficulty in the past, where for a substantial period of time he was adjudged unfit for licensure. And Ron did not want to be in a position where he had an investment and his brother, who was handling and still handles the day-to-day business of the track, was unable to function in that capacity. So his continued licensure has been and is a protective measure to protect his investment in Turf Paradise. He has no intention to build a racetrack, to go into competition with Turf Paradise, or to do anything that would be negative or adverse to the best interest of racing. It is his desire, assuming that this all works out favorable to him, it's his desire to see Turf Paradise be able to expand into off-track betting or Racino if that's feasible, in order to broaden the profitability of the track and to provide greater opportunities to those in the industry for a larger share of the revenues that could be forthcoming from those related business activities. I hope I've answered the chair's
Yeah,
question.
thank you.
Thank you.
Does anybody have any questions they'd like to ask?
Well, Mr. Chairman, I have a number of questions, but I think I'd rather understand how this process is supposed to work today before I start digging in.
Well, I think I agree. What I'd like to do is have a motion to go into executive session, but first I think can we deal with the business at hand first, Cassie, and then move to go into executive session? I mean, I'd like to take care of all the requests for fair dates, and I don't want to keep everybody here for a long period of time if we can, or do we have to deal with this issue?
I would think, based on the fact that we have attorneys here as well, that it'd be best to try and get this done as quickly as possible to release them, because some of them may have court calendars that they need to take care of and obligations in that way.
What do you think?
You could go into executive session whenever you need legal advice. If you want to go through the procedural issues like you've been doing so far and have the parties have the opportunity to speak, that's perfectly fine. If you ever find that you want legal advice while you're going through it, we can move into executive session. There's no limit in how many times you could do so.
Okay. Well, yes. Thank you, Mr. Grossman. And I guess we're going to ask for a response from Turf Paradise, maybe, to just let them respond to what you said.
I think that's only fair.
All right. Thanks.
Thank you, sir.
Good morning. My name is Jim Torrey. I'm here on behalf of Turf Paradise, TP Racing, and Jerry Sims. I'm Mike Manning's partner. Mike, unfortunately, couldn't be here today. Just a couple things about what Mr. Grossman said. Ron needed a license because he was a 10% owner, and any 10% owner needs a license. It had nothing to do with Jerry. And also, Mr. Grossman was talking about Ron protecting his investment in the track. I just want to make it clear that, as you all know, Ron was dissociated as a TP Racing partner back in January 2014. So he's played no role in the track for well over a year and a half now.
Thank you. Yeah, that's my understanding, that 68% of the partners in Turf Paradise voted Ron out of the partnership. So I wondered.
May I respond to that one point,
Absolutely.
please? Ron did not consent to any disassociation. Ron is challenging the disassociation. Ron is arguing in the civil proceeding that that was an illegal, unlawful act taken without his knowledge, participation, or consent. It is correct that since that vote was taken, Ron has been cut off from all financial information, partnership agreements, partnership decisions, financial issues. He has been totally cut off from any knowledge or information concerning Turf Paradise. He has attempted to obtain that information, and we're now currently attempting to obtain it in the civil proceeding. So Ron does not accept the fact that he has been disassociated. Jerry attempted to buy one of his interests out. Ron did not accept it. Jerry accepted it on behalf of Ron. It's a nice job if you can get it, but that's the story on the claimed disassociation or expulsion. The expulsion was based upon the issuance of the notice of denial and a provision in the notice of denial that Director Walsh had drafted for him by former chair of this commission, Mr. McDonald, which said that Ron has no ownership interest and they have no ownership interest of any kind whatsoever going forward. That provision was thrown out with the ALJ decision in recommending that the notice of denial be reversed and license be issued. And it is our position that now that that has occurred to the administrative law process and the deference to that decision by Interim Director Casillas, that that effort of disassociation and the grounds for it are null and void.
Okay, and I think Mr. Torrey would like to respond again.
I have no doubt, but I won't bother taking more of your time on this.
Thank you very much.
And I don't want to take too long either, because I know that Mr. Grossman and I could go back and forth all day with our legal arguments. And frankly, ultimately, I think that this isn't necessarily relevant to jurisdiction or party agreed. But when he does say things that aren't true, I don't want you to be left with the wrong impression. And there were a number of things he said that weren't true. The order from the ALJ didn't say that Director Walsh's statement that Ron needs a license to participate in TP racing was wrong. In fact, it's plain and simple that he does need a racing license to participate in TP racing. And what he said about the buyout is also not true. Once Ron was dissociated pursuant to statute, TP Racing had to purchase his partnership interest. He wasn't just robbed of his interest. He wasn't taken it away. We did a valuation. We paid him what we thought he was owed. He has the right to challenge it, which is what he's doing. And then a court will determine a fair value of his interest, and he will get paid a fair value of his interest pursuant to the statute. So that's what's going on with the buyouts. And, you know, again, the idea that this is a guy who wants to, rejuvenate racing is just laughable. He said he is not a horse person. That's a bit of an understatement. I remember I deposed Randy Fozzard, who some of you might know, who was the longtime general manager of Turf Paradise, but both before and after Jerry bought the track. And Randy said that Ron didn't know which end of the horse ate and which end of the horse the food came out at the end. This is a man who's suing to kick Jerry out. He's suing to shut down the track. And again, I don't know what any of this has to do with jurisdiction, but since Mr. Grossman brought it up, I thought I should address it because I don't want to leave you guys with the wrong impression.
I have a question. Is and it's probably a stupid one, is the disassociation issue relevant to whether Ron's able to hold a license? I mean, can you have a passive non-owner in Turf Paradise be a licensee?
Well, in order to be an owner, a 10% or greater owner of Turf Paradise, you need to have a license. And also to be involved in management, as Ron was to a limited extent before, you need to have a license. Now, of course, Ron's not a partner, so he doesn't need a license, but he's applied for an owner's license anyways.
Thank you.
Mr. Chairman?
Yes.
Do we just, from here on, just go back and forth and we ask questions? Or is this the day we're going to hear the appeal? Or what?
This is not
Tell
the
me
day.
what we're going to do.
Well, this is not the day. First, we have to determine if we have jurisdiction over this matter. So we will not hear the appeal.
The process starts with, right now, we're going to determine whether or not we have jurisdiction. And I didn't hear them talking about that at all.
That's in the briefs.
Yeah, that's.
I got that, but I ran through all that, but it sounds to me like they're a little further down the line than where we should be.
I think they were just answering my questions that came up from reading the briefs and the ALJ decision, and I'm trying to get my mind around what our legal role is in this whole matter. So, I mean, I would entertain a motion to go into executive session.
So moved.
Second.
All right, it's been moved and seconded that we go into executive session. All in favor?
Aye.
All right. So
Thank you. Sorry, everyone.
it's an open meeting.
Okay, this is the resumption of the 638th regular Racing Commission meeting of Thursday, October 8th, 2015, and it is 10:51. Go ahead, Mr.
Thank you. All right, that executive session raised more questions than answers. We are trying to decide. I guess there's some things we need to talk about in open meeting. So if you guys would like to bring up the things that were not appropriate to talk about in executive session, let's do that now.
Well, Mr. Chairman, I understand that there's two parts to this. That we have to decide whether we're going to accept jurisdiction, and we need to do that first. Is that right? From the legal advice that we've received.
Yes.
That's correct.
So with that, then, I would suggest then that we hear the arguments pertaining to that.
Now the question is, are we prepared to do that today, or do we want to do that at a later meeting?
That's up to you, but I think the sides are ready to discuss that today, and then you could determine whether or not you want to make that decision today.
Okay.
Council ready to present today?
Yes, Mr. Chairman, we are.
Okay.
Mike Manning's not here today. We'd like to have Mike argue, but we are ready to go ahead if you want to go ahead. Assuming you read the briefs and you're all ready to go ahead.
Yeah.
Do we need a motion?
I think you just invite Mr. Grossman up.
Okay. Mr. Grossman, would you like to come and tell us why we shouldn't hear this matter? Yeah, we're going to have to, we'd like to keep this brief if we could, so
This is not all jurisdiction.
10 minutes, please.
I'm sorry.
Right.
I'll start if this isn't too much of a distraction.
Not at all.
Marshall Grossman for Ron Sims. And I appreciate the opportunity of the oral presentation because it helps to put some flesh on a very complex statutory framework. And I will be the first to admit that that statutory framework is not totally clear. And what I'm going to try to do here is address it as easily as I can and stress as much as possible the common sense considerations of what we're dealing with here today. I won't go into extensive background on Ron, other than to note that he has been licensed consistently for 15 years. And what changed all of that is what occurred in the civil litigation, where in 2011 the Superior Court heard evidence claiming that Jerry Sims had improperly taken $2 million from the TP Treasury for his own use and other alleged misconduct. And after 7 days of cumulative testimony, the Superior Court issued 2 injunctions to stop Jerry from engaging in misconduct in his management role of Turf Paradise. Those injunctions protected both Ron and this institution. It was only in response to those losses in court that Jerry, with the aid of his counsel, worked very hard on an ex parte basis, as noted by the ALJ, the administrative law judge, to deny Ron his license. Ron appealed the denial to the Office of Administrative Hearings, and over several months, Judge Douglas heard 15 witnesses, including Ron Sims, who was examined and cross-examined for 3 days, and he reviewed hundreds of exhibits consisting of thousands of pages. We were gratified to hear Mr. Casillas answer the chair's question and state that he did not disagree with the judge's findings or his recommendation that the denial be reversed and that Ron be issued a new license. We were also gratified to hear Director Casillas speak positively about the effort put in by Administrative Law Judge Douglas, who unfortunately has been so roundly criticized by Jerry and TP Racing in their briefing, and regrettably so. So what were the interim director's responsibilities? He had options available to him under the law. He could reject, accept, or modify the ALJ decision, or he could do as he did, and that is to defer to the ALJ decision and permit it to become final. He elected that option, and it was within his discretion to let the ALJ decision become final and save this department, this agency, more time and expense than it has already incurred in this matter. The interim director and the Department of Gaming had various avenues available to them to challenge the ALJ decision if they chose to do so. They had the right to seek a rehearing from the ALJ. They had the right to appeal the final decision to the Superior Court. They elected not to do either. And they are not the only parties to the proceeding who acted in a statesmanlike, appropriate manner to put this issue behind us. As the prevailing party, Ron Sims had the right to petition the Administrative Law Judge to order the state to reimburse him for several $1 million in legal fees that he had incurred in going through the hell of the notice of denial process and the subsequent judicial proceedings before the ALJ. Ron Sims did not do so. He did not ask for the reimbursement of his legal fees. He didn't do so because he intended to demonstrate that he wanted this chapter closed once and for all. These were sound decisions by the actual parties worth your consideration. I have a draft letter from Mr. Casillas written just days after the ALJ decision was issued. I don't know whether the letter was final and went out. I assume it did because it went to the state risk manager asking for more money for this agency. And what he wrote there was what he just explained to you earlier. He said that, and which I'm discussing now, he said that when the administrative law judge assigned to hear the matter issued his recommendations to me, under statute, I have 30 days to consider whether to accept, reject, or modify that recommendation before it becomes a final administrative decision. Not before this commission has jurisdiction to pass on it. No, but before the administrative law area in the OAJ had the right to decide it. He also stated clearly that the legal fees related to these proceedings have far exceeded his expectations. He noted that ADOR is currently left with outstanding expenses that exceed its fourth quarter appropriation, despite having a staff reduction and a 12-day employee furlough throughout the entire agency. He also correctly noted that Ron Sims had the right to seek his attorney's fees. He said further, we understand that Mr. Sims may seek to recover his fees as the prevailing party. Whether he may or may not be entitled to fees, and while we do not know what his fees are, it's safe to assume they are quite high. And they were. And we made it known clearly before we had any understanding of what steps Mr. Casillas would ultimately take or the departments would take. We made it clear that Ron Sims was not going to further encumber this agency or the state of Arizona with additional legal fees. or even ask for. The Racing Division of the Department of Gaming has recently conducted a new investigation of Ron's fitness for licensure and issued Ron a new license. Ron is licensed today. That doesn't obligate him to go out and build a new racetrack or anything else any more than receiving a driver's license obligates you to drive on the highway. But for business and personal reasons, he wanted that license, not just for the license, but to restore his good name and his reputation. I'm now going to speak to the direct code sections that we believe are appropriate to mention here. I'm referring to ARS 41-1092.08 and ARS Section 5-104. TP Racing and Jerry filed an objection with the OAH, claiming that its decision should not have been certified as final. He wrote them that, and Presiding Judge Hatchett, the acting interim director of the OAH, wrote in his opinion, which you'll see on slide 3 here, he wrote that the OAH acted in accordance with the governing statutes in certifying the ALJ decision as final. Each of these slides that I refer to are in the little booklet before you. Jerry claims that you have jurisdiction to review the ALJ decision because he says it became a decision of the director when the director deferred to the ALJ decision. Jerry relies on ARS Section 5-104D, that's slide 4. But he only relies on one of the first sentences. He does not give any credence to the second sentence, which refers to when the commission might consider an issue. That reads, the commission may hear any appeal of a decision of the director in accordance with Title 41, Chapter 6, Article 10. And that is critical, because what does that say? That's in slide 5. And this is a little stilted language, but I'm going to try to help you get through it. It took me a long time to get through it myself. If the head of an agency does not accept, reject, or modify the ALJ decision, as happened here, did not happen, within 30 days after the date OAH sends a copy of that decision to the head of an agency, as evidenced by receipt of such action, the ALJ decision is certified as the final administrative decision. Mr. Casillas, in that same letter, recognized that, as I mentioned earlier. What TP Racing argues is that by not taking action, by deferring instead of taking action, that is the same as acceptance. And that means that it cannot be certified by the ALJ as a final decision. But if that's the law, then no action taken by the director, acceptance, modification, revocation, or deference, could ever go back to the administrative law court or agency for certification. That can't be the law. It does not make sense. And that language in that statute is consistent with ARS Section 41-1092.08 F1. Let me now refer to slide 7. ARS 41-1092.08C does not allow the Commission to review an agency head decision and make the final administrative decision because it treats because the ALJ decision was not accepted, was not rejected, or modified. Section D of that same section expressly provides that under these circumstances, the final administrative decision is to be made by OAH. Jerry's interpretation makes no sense. Under Jerry's interpretation, whatever the interim director did could never be certified as final by the OAH. That's not common sense. It's not the law. There is one provision which gives the Commission jurisdiction under certain circumstances, and that is ARS 41-1092.08C. It gives the Racing Commission review power if, and only if, the interim director did not act by formally accepting, rejecting, or modifying the ALJ decision.
Did act.
Did act. Only if the interim director did act by formally accepting, rejecting, or modifying the decision. He didn't do any of those things. Therefore, this commission lacks jurisdiction under that statute. But Jerry also ignores the rest of subsection D, and that provides that the acceptance, rejection, or modification must have occurred within 30 days of the date the OAH sends a copy of the decision to the head of the agency. Here, the ALJ decision was sent to the agency head since it was review of the director's notice of denial. But under Jerry's theory, if this subsection governs review by the commission only had 30 days to accept, reject, or modify the ALJ decision. And it didn't do so within the statutory period of time. So even if you had jurisdiction, and we respectfully submit that you did not in this case, it's been lost by failure to act in a timely basis. Here, there is no decision of the director to review. I'd like to close with a brief discussion of the session law. The session law became the law on July 3rd, 2015. It is clear from that language that the commission lacks quasi-judicial jurisdiction. What is quasi-judicial jurisdiction? It's the jurisdiction of a good agency such as yours to act in an adjudicatory capacity. It has nothing to do with your powers and responsibilities to the constituency sitting here in the audience. We have not, and we will not, and we did not ever urge that this commission be disbanded, treated as a nullity, or have no jurisdiction whatsoever. We are singularly focused here on this provision of the section law, which, unlike other laws that I've been referring to, is crystal clear. All administrative matters, contracts, and judicial and quasi-judicial actions, whether completed, pending, or in process, of the Arizona Department of Racing are transferred to and retain the same status with the Department of Gaming. There's nothing ambiguous about this, nothing at all. In fact, Andrew Gordon, who I know is a very respected lawyer in this state and beyond, considered the competing arguments of both Mr. Manning and me. And in his email, which is in slide 9, he concluded that this commission does not have jurisdiction to consider this matter. Not any matter, not every matter, but this matter. How does Mr. Manning, on behalf of TP Racing and Jerry, deal with this? They argued that the section law simply, quote, clarifies, close quote, in their view, that after the merger of gaming and racing, the commission will not have new powers over the business of Indian gaming. That's what they tell you in their brief. But nothing in this section law mentions Indians or Indian gaming or the commission having no new additional authority. It states very simply that it has no jurisdiction over judicial and quasi-judicial actions. We request that you find that you do not have jurisdiction. The scare tactics that it's going to put you out of business, that Ron is out to menace you, are scare tactics. I have articulated our position. We have done so in our briefs, and that is our request. As a matter of 100% candor with you, if this decision goes against us, then we will have no alternative, no choice, but to go to court and seek an extraordinary writ or special action, testing the jurisdiction of this commission to hear this matter. Nothing else other than jurisdiction. And if we should lose on standing, obviously standing on respective due process rights. I don't want to spend another nickel of my client's money. And I don't want to see you or this state spend any more money that belongs rightfully to help these people sitting here in the audience. You can continue doing the wonderful job that you're doing and the outstanding job that Director Casillas is doing and everybody else associated with racing and gaming are doing. And you can put this matter to rest. It's not your fight. Somebody asked me outside, how far back does this go? And I answered, I think it goes to the playpen. It's not your fight. It's in the Superior Court. The court is well equipped to resolve all of these issues. And I thank you, Mr. Chairman, and your colleagues for giving me the time and space to say what I really had to say in order to set this record clear.
All right. Thank you, Mr. Grossman. Does anybody have any questions for Mr. Grossman? Okay, Mr. Torrey.
Thank you.
Thank you. Okay. Thank you. Well, thank you very much for giving me another chance. Mr. Grossman is certainly an elegant speaker, but it's interesting the distraction techniques he tries to get you focused away from what the real issue is here. The real issue here is this isn't about this particular appeal. This is a question of whether this commission has jurisdiction to hear any appeal when a license is granted or denied, and then the director takes no action, and that becomes his decision. So this isn't just about this appeal. This is about your jurisdiction to hear any appeal, and the law is clear. The law is absolutely clear. This is a no-brainer, which is why I think we've heard Mr. Grossman try every technique in the book to try to get you distracted. We heard about how Ron forego legal fees. Well, what does that have to do with jurisdiction? We heard about the great merits of Ron's case and how right he was. Well, what does that have to do with jurisdiction? We heard about Jerry took $2 million and got an injunction against him. Well, that, by the way, is absolutely wrong. It's not true. The allegations are completely false, and I would love to sit here and tell you all about it, but it is irrelevant. It is a distraction. It is what he is trying to distract you, to get you to think about other things and not focus on what really is relevant, which is, do you have jurisdiction in this case? And I think it's interesting, with as long as he talked, that he didn't talk about the main statute that governs this and the main statute that shows that you do have jurisdiction. And that is ARS, and this is ARS 5-104B. We didn't hear anything about that. And that statute says the director shall license personnel. And then it goes on to say the director is subject to ongoing supervision by the commission. And the commission may approve or reject decisions of the director in accordance with rules established by the commission. Didn't mention it. Why? Because it makes it absolutely clear that it's the director's job to give out licenses, and then it's your job to review all decisions of the director. All decisions of the director. Mr. Grossman also said, "Oh, we've spent so much money. This has gone on for so long. You know, let's let this end." Well, that's not your function. You were set up by the legislature as a public protection function. This is a public protection body. You're there because we're in a gambling and horse racing business. It's a heavily regulated business. You're there to make sure things are done right. And while Mr. Casillas and Mr. Walsh and all the other directors try to do their best, sometimes they make bad decisions. Mr. Grossman's argument is, if Mr. Casillas had a particularly bad day and gave a license to, pick your favorite villain, Osama bin Laden, Kim Jong-il, whatever. He came and applied for a license. Mr. Grossman's argument is, if Mr. Casillas read the application, whatever, gave him a license, you're powerless to hear an appeal. You can't do it. His decision is final, and that is not what the law says. The statute says the director licenses personnel, but you supervise them. So then Mr. Grossman said, well, here there really wasn't a decision by the director, because he said what happened was the ALJ made a decision, and then Director Casillas simply deferred to it. He didn't accept it. Well, that's taken care of in ARS 5-104D, which says the commission may hear any appeal of the decision of the director, and the decision of the administrative law judge becomes the decision of the director unless rejected or modified by the director within 30 days. So Director Casillas did make a decision. His decision was he essentially accepted it by not doing anything. But he can't destroy the jurisdiction of the commission just by accepting it by not doing anything, as opposed to accepting it by affirmatively saying, I accept it. ARS 5-104D says it's still his decision. Now, Mr. Grossman also mentioned, these are the statutes. This is what the legislature said. And Mr. Grossman then cites to a portion of the administrative code dealing with general administrative agencies, not dealing with the racing department specifically, but dealing with all administrative agencies. And he said that because OA certified the decision as final, that means you somehow lose your appeal rights. Well, that doesn't make any sense when you look at ARS 5-104B, which says you shall review them. And it doesn't make any sense with respect to ARS 5-104D. Also, if you look at the last one I have down there, which is ARS 41-1092.08C. Now that is the section that immediately precedes the section that Mr. Grossman cites. And that said a board or a commission whose members are appointed by the governor, that's us, may review the decision of the agency head as provided by law and make the final administrative decision. And that is what this section is referring to. The commission may hear any appeal of a decision of the director in accordance with Title 41, Chapter 6, Article 10. That's that section. So Mr. Grossman is saying, despite the fact that this section, 5-104B, says you can review decisions, and despite the fact that ARS 5-104D specifically says that you can review a decision of the director after he takes no action on an ALJ decision, and despite the fact that this section says the last one, 41-1092.08C, says you can review any decision, he says that somehow he's interpreted Section D to say that overrides all of this. None of this matters. You can't do an appeal. That is crazy. You have to understand that Part D is a section that applies to all administrative agencies, not just the Department of Racing. So Part C, right, deals with the situation we have here, where a board or commission whose members are appointed by the governor oversees a director. That's us. But there are other agencies, many other agencies in Arizona who aren't like that. Some of them just have a director. Some of them just have a commission. And that's what Section D deals with. It says that in that situation, when there's just one person and he makes a decision and NOAA says it's final, then it's final. But that can't override all of these other statutes. That makes absolutely no sense whatsoever. And in fact, Mr. Grossman mentioned a decision by OA. It quoted from it. I think it was the first board he showed you. But even that OA decision, he didn't quote all of it to you. This is what the OA decision also said. OA is unaware of any authority that would bestow upon OA the ability to determine a reviewing entity's jurisdiction to review a decision certified under that statute. The reviewing tribunal, which is you, the Racing Commission, must make that determination. And in the end, the statutes are crystal clear. There's a good reason why they didn't even mention the main statute dealing with this, and that's because it makes it crystal clear. And when you combine that with Part D and Part C down there, there's absolutely no question whatsoever that you have jurisdiction to hear not only this appeal, but other similar appeals. Mr. Grossman also cited the session bill. The session bill he cited says, quote, the Arizona Racing Commission has no authority over the duties and responsibilities of the Department of Gaming. That's what he cited. So what are we doing here? If there's no authority, then why are we approving OTBs? Why are we approving anything? What he said makes no sense. The legislature didn't cross out this statute, didn't cross out any of these statutes. It could have. What it was trying to say here is it was merging the two departments, racing and gaming. And it wanted this commission to continue to review racing, but it didn't want you all of a sudden to now have authority over gaming matters. It didn't want you to all of a sudden be reviewing things having to do with Indian casinos and whatnot. So it said the Racing Commission has no authority over the duties and responsibilities of the Department of Gaming. They interpret that as wiping out all these statutes. The legislature would have crossed them out if it wanted to wipe out all these statutes, and we wouldn't be here if they were right. So I think there's no question about the jurisdiction. If you have any questions, I'll be happy to answer.
Thank you, Mr. Torrey. Question.
Well, I'd like to hear from Mr. Grossman. Could you leave that up, Counsel?
Sure. I was helped enormously by my partner, Stacey Harrison. May she respond to your questions here?
That would be fine.
Thank you.
Good afternoon. I also represent Nonsense.
Okay. Counsel, these statutes look crystal clear to me, and they weren't mentioned in Mr. Grossman's presentation. How do you respond to Mr. Torres' argument, which was very persuasive to me?
Well, actually, if you go to slide number 4 in our booklet, we did cite this very statute, ARS Section 5-104D. And
B, though. B to me is the main one. The first square there.
That is correct. So we did not cite that provision, but that provision says that the commission has authority to oversee decisions of the director. And here we don't have a decision because the director did not act. He did not act to accept, reject, or modify the decision. So if you go to D...
I'm not sure I buy that, because isn't non-action accepting the decision of the ALJ?
Not under this section. It says the commission may hear any appeal of a decision of the director in accordance with Title 41, Chapter 6, Article 10. So you don't have overall discretion to review any decision of the director, even if under this particular statute, no action is a decision. You have to go to 41-1092.08. And that's actually on page 5 of your booklet. So it's a little bit of a decision tree, but you have to follow the statutes. So we have 104B and D that says that the commission has review over decisions of the director, and that the ALJ decision becomes the decision of the director. But then there's restrictions on what the commission can do depending on the type of decision that the director makes. And if you go to D in page 5 of your booklet, it states that if the head of the agency does not accept, reject, or modify the administrative law judge decision within the time period, then OA, the Office of Administrative Hearings, shall certify the administrative law judge's decision as the final administrative decision. So while ordinarily you would have jurisdiction to review a decision of the director, for example, as Mr. Torrey pointed out, if the director had a bad day and licensed Osama bin Laden, you then would have the authority, the jurisdiction, to review such a decision. But here, when there's been an administrative law decision after a hearing, and the director has 30 days to act and he doesn't, under this code section, 41-1092.08D, it becomes final. And the reason we know that is that if you go to, and it is the 7th slide or 7th page in your booklet, you go to section C, I'll let you get there. If you go to Section C of the same exact statute, so we've been looking at D that talks about how OWA will make the final administrative decision. If you go to C, it states, a commission may review the decision of the agency head as provided by law and make the final administrative decision. The only way C makes sense is that the director actually made a decision, because otherwise you would have a statute that reads that two different agencies are making two final administrative decisions, and there can't be two final administrative decisions. The only way this statute makes sense in reading it together is that if the director accepts, modifies, or rejects the decision within the applicable time period, then under C, the commission would have review of it, and you would have the ability to jurisdiction to make the final administrative decision. Here, under D, because the director made no decision and deferred, there is no jurisdiction, and OWA makes the final administrative decision. And the reason why this makes sense is that the commission's job is to review decisions of the director, actual decisions that he makes, not decisions of an administrative law judge. So ultimately, there's no decision for the commission to review. Also, the statutory scheme gives the director the discretion to make no decision and put an end to the proceedings. Now, this isn't typically what happens, I understand. I mean, typically a director would do something in order to allow the commission to have review, but in this case, that is not what happened. And so under the statutory scheme, it only makes sense that since there's been a final administrative decision issued by OWA, this commission cannot issue the final administrative decision.
So our jurisdiction is totally dependent on whether Mr. Casillas responds to an administrative law hearing, whether we know the decision or not, because we haven't had a meeting. We're completely neutered if he decides, and I just have a tough time believing that's what the legislature decided. We're in 5104B. I mean, to me, inactivity could be a decision. That he decided not to oppose it. It became final, but I don't believe that neuters this commission from challenging it or hearing an appeal.
Well, if it helps, there's another section in the same statute. It's on page 6 of your booklet, F1, that states, the decision of the agency head is the final administrative decision unless the agency head does not review the administrative law decision or does not reject or modify the administrative law decision, in which case the administrative law judge's decision is the final administrative decision. So I understand that it seems a little odd that the commission would not have jurisdiction when the director doesn't act, but that is what the statute says, and that is the law, and it makes sense in the sense that your review is over the agency, it's not over the administrative law judge.
Thank you, Mr. Flores. I'd like to. That was a very compelling presentation.
Thank you.
Both did very well.
I think I could be brief on this. Again, she's citing statutes from the General Administrative Code that deal with situations when you only have a director or a commission, not with both. Again, D deals exactly with this situation. It says the administrative law, the decision of the administrative law judge becomes the decision of the director, unless accepted or rejected or modified within 30 days. And then it said, you can appeal that decision. That's the statute. And then their argument is, well, when you go to Part D of 41-1092.08, that completely neuters all this and makes these sections totally irrelevant. These are the racing statutes. She is citing to the General Administrative Code, and moreover, she's citing to the General Administrative Code that deals with situations we do not have here with this racing commission. We have a director and we have a commission appointed by the governor. So there we have Part C applies, which says a board or commission whose members are appointed by the governor may review the decision of the agency head as provided by law and make the final administrative decision. I mean, frankly, I think it's pretty clear. And if you have any other questions, I'll be happy to answer. Thank you.
Thank you, sir.
Thank you. Mr. Chair, members of the commission, my name is Joseph Kingfield. I am counsel to the Department of Gaming in this matter. I just very quickly wanted to clarify one thing with the commission, which is that after the administrative law judge had made his recommendation to the interim director Casillas at the time, Mr. Casillas had separate counsel, who was Andy Gordon, who was advising him if he had any questions, because we were advocates defending the department's decision to deny the license to Mr. Ronson's. And there was a communication that was offered that showed Mr. Gordon offering his opinion that the commission does not have jurisdiction. I just want to clarify, we have since filed a notice with the commission indicating the commission the Department of Gaming takes no position on this question of whether the commission has jurisdiction. It's deferring to the commission on that point. So,
Thank you, Mr. Kingfield. Well, you both have made very compelling arguments on both sides of this very confusing issue, and you've managed to confuse it a little further, so I guess sooner or later we need to make a decision.
I have a question of our council. Do we have to decide the jurisdiction issue and then move to the aggrieved party, or hear them both and make it? What's the recommended procedure?
You can decide whether or not you want to hear everything and then make a couple of motions at the end of this part of the meeting. You can decide to rule on jurisdiction first and rule on person three. It's really up to you.
Okay.
And you can go forward to you can move forward as if you want to, and then, or you can decide right now.
Okay. I would too. I make a motion that we find that the commission has jurisdiction in this matter.
I second it.
Do you want to state why?
That statutory language under the Department of Racing statute was fairly clear to me.
Okay, it's been moved and seconded that the commission has jurisdiction over this matter. All in favor?
Aye.
Opposed? Motion passes.
Well, now I'd like to move to the thornier issue for me, and that's the aggrieved party argument. And I don't know if Mr. Torres should go first, or
I don't have a preference, Mr. Torres. Lead us off, please.
Okay. Here again, I think the issue is relatively clear-cut. The regulation at issue says that a person aggrieved by a ruling of the director may appeal to the commission. And that specific language that was used, and this is a commission regulation, this was drafted by the commission, is very important. It doesn't say a party aggrieved by the decision may appeal. It says a person aggrieved. So it was intended to show that more than just the parties were able to appeal. And that's shown even more when you look elsewhere in that same statute. Elsewhere in the same statute, when it talks about commission reviews, it does say a party aggrieved. So there it was limited to parties. Here it went beyond that and said we're going to allow any person aggrieved to challenge. And first of all, I'm sure you've read the briefs, and Ron cited some case law in there. First of all, that case law he cited is utterly irrelevant to this decision. None of it deals with the interpretation of this particular administrative code. It deals with situations where a party in superior court are appealing to go to the Court of Appeals, or it deals with a different administrative code. In fact, in the other one where it dealt with the administrative code, there the words were person aggrieved, and there they found, the court found that there was, the party seeking jurisdiction was aggrieved. So those cases do Ron no good. Ultimately, it's your regulation. You wrote it. You have discretion to interpret it. And under the plain language of it, I think TP Racing is clearly aggrieved. And we went over this in a little more detail in our memo. I'll touch on them a little bit. But Ron is already taking this decision. Now remember, we weren't a part of the OA proceeding. We weren't lawyers there. We didn't get to ask any questions. We didn't get to introduce any evidence. Jerry wasn't a witness at all. Mel McDonald, who they bash in the decision, wasn't a witness at all. But they're already taking this into the court and using it against us. They said it, I think, 62 times recently in response to our summary judgment motion. And their argument is that somehow this is binding on us. And it's inconceivable to me that they can take this into court, use it against us, but somehow we're not aggrieved by it. We just have to take it and accept it. He's even using us, as we mentioned last time, we showed you, to try to shut down the track, showing that the partnership can't get along. He's trying to shut down the track.
As a minority owner, how would he have the ability to shut down the track? It's my understanding that Mr. Jerry Sims is the majority owner. In what fashion could he shut down the track?
Well, he's brought a claim. It's his count 31 of his counterclaim. And there are statutes that allow for the judicial dissolution of a partnership upon the claim of a partner. Now, granted, our position is he's not a partner. He was dissociated. But nonetheless, he's still arguing that in court. So that's what he's trying to do, pursuant to, I don't have the statute off hand. I could get it for you if you wanted, but he's trying, pursuant to statute, to get it judicially shut down.
But aren't ownership and licensure two separate issues? I mean, if he's out there holding a license, that has no bearing on the ownership, whether he's an owner of the track or not. I'm having a hard time figuring out the aggrieved person issue, because I want to know specifically how Jerry would be prejudiced, either property right or whatever right is required, just by having another licensee out there. I don't think it has a bearing on the lawsuit. I don't think it has a bearing on his ownership. That'll ultimately be decided by the courts.
Well, we are aggrieved by the decision. What we're doing is challenging the decision, saying that the decision is wrong. And he is taking this decision into court and saying, this is evidence.
Yeah, but that doesn't have to do with us.
Yeah.
What does that have to do with us? Explain to me what the court does.
I mean, you can review that in court.
No, that's right, and we can challenge that in court. But let's say he's right. Let's just assume for a second that he's right, and somehow this is binding on us, even though we should have a chance to challenge that here and say, no, it's not. All these things that were said were wrong. They're based on lies. But I'll go beyond the court. It has nothing necessarily to do with the court. Let's think about the fact that there is a decision out there, a public record, that anybody can go get. And it's a finding by the racing department. And it says that Jerry Sims and TP Racing's lawyers, Mel McDonald, were engaged in improper conspiracy to have Ron denied a license. More than that, Ron's story at the hearing was that Jerry and TP Racing and Ador along with Ron, engaged in a secret oral side deal back in 2000, whereby, this is the story, and the decision bought it, incredibly, that the capital contributions that were given for the partnership when the track was bought, the capitalization of the track, is not as it's written down, it's not as the documents say, and it's not as was given to ADOR and put into the public record. They say they doctored up these promissory notes that are supposedly on-demand promissory notes, but really there was a secret side deal with ADOR whereby the documents didn't mean what they really said. Why would they do this? Well, Ron said they did this because it could have impacted his 1031 exchange, which is a tax benefit. So in other words, he's saying he's got this company over there, Brewing Corporation. If they admit the real deal, which is Ron says he could trade his land into TP Racing and have these notes canceled, if they admit that, it could jeopardize his tax treatment. It could cause him tax problems. They don't want to risk an audit. So what Ron's story is we didn't write it down. Instead, we gave ADOR these promissory notes, which didn't have the real terms. We put them into the public record, but ADOR knew, and Jerry knew, and everybody knew that that wasn't the real deal, and that the real deal was that Ron could do this. Well, I'll tell you what, if that is true, then that's a blatant, possibly even criminal violation of the public records laws. It is a possible violation, trying to hide it. A transaction from taxing authorities violates who knows how many tax regulations. And right now, the decision accepts that. It says that Ron is credible. There is a document out there right now, that decision, that says Jerry not only conspired, and his lawyers and Mel McDonald conspired to get his license denied, but that they engaged in this, and ADOR too, by the way, engaged in this fraudulent and illegal conduct. And let me ask you, I know none of you were part of this either, but let's say that at the end of that decision, the ALJ had also written, oh, and by the way, Jay McClintock engaged in fraud as well. Or, Commissioner Heupel engaged in fraud as well. My goodness, you'd feel aggrieved. You'd say, my goodness, there's a public record out there from the Department of Racing saying I did this, and I didn't do it. I want to challenge that. I'm aggrieved. You wouldn't say, it doesn't affect me at all. So I know they want to make this, oh, this is all about the court case. You don't have to get involved, blah, blah, blah. That's their story. But that is absolutely not it. And beyond that, you have to remember our whole business, TP Racing's business, is a heavily regulated gambling business. And the success of that business depends entirely on it being trustworthy and the public thinking that it's being regulated properly. And here we have a decision from an ALJ saying, and this deals with an owner's license, so this is close to home. This isn't just like, we're arguing about something that has nothing to do with our business. This is an owner license, someone who was involved in our business. And during our permit investigation, when he was asked questions by ADOR's investigators about some of his past misrepresentations, he refused to answer. And the decision says that's okay. And the decision doesn't even address a lot of his lies. I'll tell you what, if a newspaper came around, looked in the file, and saw what Ron said, the gross disparity with what he said, the dramatic lies he told this department on key issues, his absolute refusal to answer questions, and that we gave him a license anyways, what does that say about what it takes to get licensed here? Well, I'll tell you what, it says that an owner of a racetrack could stonewall the department, refuse to answer its questions, refuse to give documents that the department wants, and that's okay. There is no way that isn't damaging to TP Racing's business. By the way, one of the cases
one second, before I forget. In that record, okay, the law judge makes a comment that Mel McDonald contacted the former director. True or not true?
Mel McDonald did contact the former director, and there's absolutely nothing wrong with that.
There's nothing wrong with that.
You don't think there's anything wrong with that? That he helped guide the former director towards a decision? You don't think that's a problem?
Commissioner Feldmeyer, let me tell you, no, there's nothing wrong with a permittee talking to the director. Nothing at all. Let me tell you what happened there, because this wasn't brought out, unfortunately, by Ador's counsel. Here's what happened in that situation. Ron Sims, I was going to say lost his license. He didn't lose his license. He forgot to renew his license in 2012. So in 2013, Director Walsh discovers this. And he tells everybody, hey, Ron doesn't have a license. So we went into court after that and filed a motion to dissolve 2 injunctions that were in place that required Ron's entity's participation in TP racing. And our argument was these injunctions should be dissolved because they require Ron's participation, but Ron can't participate because he doesn't have a license. We filed that motion. A couple days after that, Ron's lawyers went and met with the director. His lawyers went and had a private meeting with the director. And in that meeting, they made, I don't know what they told the director, but the director wrote a letter. It didn't say Ron could participate, but it used this phrase day to day that Ron likes to use. Ron took that letter from the director, from his private meeting, into court, showed it to the judge, and said, this shows that Ron can participate in racing without a license. Well, you all know that's not true. All of you know that 10% owner needs a license. He was misrepresenting Director Walsh's words. So we told Director Walsh. And then Director Walsh clarified it by putting that language in. How did he clarify it? He put that language in that Ron hates, that just says, if you read the whole thing, he even says, Ron misrepresented what I said. This is really what I meant. And he clarified that Ron needs a license. So all this stuff is just ex parte and whatnot is absolute nonsense. And it was started by Ron, and it was started by Ron's misrepresentations to the court. And unfortunately, Ador's counsel didn't properly bring that out at the OA proceeding. But there's a lot of things, believe me, there's a reason they're fighting tooth and nail to keep you from hearing this appeal. Because if you hear this appeal, there is no way you're going to turn it down. But beyond that, think of this. Ron seems to be saying that the only people who can ever challenge a grant of a license are the parties to a proceeding. Right? Only the parties can challenge it. That makes no sense. You saw the statute that said...
We're past that.
No, but
I just need to know how your client is aggrieved.
Right, and I'm getting there, Commissioner Feldmeyer. But the background, that's...
You don't have to back up to get there. You can keep going forward.
Okay, well, I'm done backing up. I'll go forward now.
Okay, good.
Because you can challenge all decisions, think about a situation where a party is given a license. When a party is given a license, who's going to challenge it? Well, Director Casillas isn't going to challenge it. He gave the license. Right? Ron's not going to challenge it. He got the license. None of the parties are going to challenge it. So there has to be somebody besides the parties that can challenge this, or it's unchallengeable. And this,
we believe it's challengeable. We just want.
Okay, and what I'm saying, right?
Good question. How? Give us specifics on how Jerry Sims is aggrieved.
Right, and that's what I was doing. My point is, one of my points is, if Jerry can't do this, if TP can't do this, who can? Who can challenge this? Who's closer to the situation than us? Who is named in there? Who has a public record out there saying that they engaged in fraud? Who has a public record out there saying that they engaged in criminal activity? Who else is Ron using this against in court, saying this is binding on you? Who else runs the racetrack whose credibility is being called into question by this very decision? Nobody. There's no one closer to this decision than TP Racing and Jerry. Let me give you an example. In one of the cases they cite, the Scenic Arizona case, where they used the person aggrieved language. Don't want to make that mistake. That was a situation, and again, it's a different statute, so it is irrelevant, but I think it's a little bit telling. That's their case. It dealt with a billboard over on the I-17 freeway. And there was a billboard there, but they wanted to make it an electronic billboard. And there were some citizens groups who challenged it and said, we're persons aggrieved. And they said, no, you're not. Well, the court found they were persons aggrieved because, number one, it could upset their aesthetic viewing of the I-17 freeway. Okay. Number two, if they decided that their aesthetics of the I-17 freeway were so damaged that they had to drive a different way, well, then it might take them longer to get where they're going, and it might take up gas. That was enough. What I'm saying is the standard isn't very high. And here we have a decision that we didn't have a chance to participate in. And in fact, they did everything they could to keep us out of, accusing Mr. Sims, our lawyers, and everybody else of a fraud, and it's out there for anybody to see. There's no way we are not aggrieved by that decision. And I think you'd agree with me that if your name was in there, you'd feel aggrieved by it too. And like I said, if we can't challenge it, who can? You're basically saying this is an unchallengeable decision. I mean, is one of the horsemen closer to this than us? Is one a jockey? I don't know. Nobody's close. Somebody who runs the concessions, if we can't challenge it when they're talking about our partner and ownership in our partner, nobody can. And we might as well throw 5104B and D out the window because nobody can challenge this.
Any other questions?
I do. I've got a couple of them. So it's your belief that anybody can challenge?
No, not anybody. But clearly, by virtue of the fact that this deals with our business, it deals with Jerry Sims specifically, it deals with TP Racing specifically, it's being used against Jerry Sims and TP Racing specifically, and it impugns and impacts negatively and can be viewed by anybody upon TP Racing and Jerry Sims specifically that we're aggrieved by.
So if I follow that accurately, then your opposition could say the same thing about your client when he comes up for his review of his license. Is that right?
Well, I don't know. I mean,
somebody's got to know.
Well, Commissioner Feldmeyer, if there was, let's say, if my client had his license denied, and then it went to a hearing, and then the decision at the end of the day said, this is all Ron Sims' fault and Ron Sims engaged in crimes, then I guess Ron Sims would be aggrieved by that, yes.
So then we'd be going through the same thing here that we're going through today. If that occurred. If that
occurred.
Okay. Go into it then.
Any other questions? Thank you, Mr. Torrey. Mr. Grossman or Ms. Harrison?
I attended and participated in the ALJ proceedings. I think that Mr. Torrey must have been speaking about some other hearing than the one that ended up with the recommendation that Ron be licensed and the notice of denial be denied. There is nothing in the administrative law judge's decision that accuses Jerry or fines Jerry or accuses TP Racing or fines TP Racing having been involved in a conspiracy or a fraud or a crime. Nothing. This is made up out of whole cloth. And if somebody can show me those charges in the statement of decision by the American law judge, I will stipulate that Jerry may not lawfully be an aggrieved party, but I'll stipulate that he could be deemed an aggrieved party for this proceeding. It's not there. In fact, the law is such that even if it was there, it wouldn't give him standing as an aggrieved party. As an aggrieved person. Thank you. And there I refer to the case that we cite in our brief, which was a bankruptcy proceeding, and the court appointed somebody as the bankruptcy trustee who was about to prosecute Miss X for murder. And the appointment of the bankruptcy trustee facilitated that murder prosecution in another case. And that woman came into court trying to appeal the appointment of the individual in the bankruptcy court, claiming that she was an aggrieved person because he was going to be named as the special prosecutor or whatever the title was. And he was going to then prosecute her for murder. The court said, you're not an aggrieved person in the eyes of the law. We are not looking at other legal proceedings. We are focused on this legal proceeding. And this legal proceeding has been twisted into a pretzel in the presentation that was made. Many months, many witnesses, Ron cross-examined, and a decision that the director does not disagree with for its findings. If there was anything in that decision that was harmful to racing or TP racing, then I doubt the director could have reached that conclusion. The statute, or the rule rather, that they seek to rely on is very simple. And its simplicity is why it is not in accordance with due process of law. It's Rule 19-2, 124A. And it reads, a person aggrieved by a ruling of the director may appeal. That's it. That's it. You folks throughout your history have never adopted any procedures, any rules, any standards, any guidance as to how this is meant to be interpreted or how it is meant to be affected or what happens during any such appeal. It's a little bit like the Tom Brady decision in the federal court. Roger Goodell made it up as he went along in the good interests of the game. And he disciplined Tom Brady. Tom Brady took it to federal court. The federal judge looked at it and said, NFL, you have acted illegally here. You have denied Mr. Brady due process of law because you have what I think the judge referred to as industrial rulemaking. In other words, you're making it up as you go along. But let's look at the language of the rule, which Jerry Sims doesn't want to spend too much time on, notwithstanding its brevity. A person aggrieved by a ruling. Well, there are at least two elements there that are important. First, there was no ruling here by the director. We all know what a rule is. We know what a ruling is. There was no ruling by the interim director. One can quibble and argue whether there was a decision or not, but there was no ruling. Therefore, there is no grounds to appeal under that ruling, under that rule. Secondly, the term person aggrieved. The definition and required interpretation of an aggrieved person is established under law. Arizona law, your law. But they are singularly silent in discussing those cases because those cases are contrary to their position. Instead, they ask you to accept a definition from Webster's dictionary because they know they don't meet the requirements of Arizona law. They also tell you, you heard Mr. Torrey say it, you're the commission. You can decide what's an agreed person. You don't have to look at the law, look at the dictionary, but you can decide whatever you want it to mean. That's not how government agencies act, on the fly. If that were the case, one commission could have one standard of what agreed person means, and another commission, your predecessors or successors, could have another standard, and the public, and neither would your successors, know what is the standard or guideline. With all due respect, some teeth should have been put into this with specificity and clarity by prior commissions, and it wasn't done. So you can't look to Webster's dictionary, and you can't just make it up as you go along. The third issue that they have is one that I've alluded to, and that is there's no standards for any appeal by an aggrieved person. You may have some precedent in licensing because you've done a lot of it and there's been a history there, but there's no standards of which I'm aware of for this kind of an appeal. From the day she was named as your special counsel, I have asked her under what rules, what guidelines, what procedures are you going to follow here? What notice, what briefs are permitted, what isn't permitted? And her only response was, you don't have to worry, we're operating under the open meeting law. We still don't know what the rules, standards, or procedures are, and we know what happened with respect to the open meeting law. They spend most of the time in their brief, not so much in their oral presentation, but just a little, engaging in a vicious and false personal attack on Ron Sims, and they save some of their vitriol for me. Not fair. This is not a trial or a rehearing of what happened before the administrative law judge. This is an appeal, arguably. An appeal takes the record that is presented before an independent judicial fact finder, and it is examined de novo all over again. Over and over and over again, Mr. Torrey went way outside of anything that was ever introduced during those proceedings. He acknowledged it on a few occasions, but on most, he did not. He wants you to accept agreed status on behalf of Mr. Sims or TP Racing based on material that is not in the record and on material which he twists into a pretzel from what is in the record. He says in his briefing today, this is our only opportunity. We haven't had a chance to have Jerry's voice or TP Racing's voice heard. Well, whose fault is that? They could have been witnesses in the proceedings if the Attorney General's office or even Mr. Canfield thought that they would be helpful to ADAR, but they weren't called as witnesses. If they wanted in badly enough, they could have petitioned the judge for leave to intervene in the proceedings, and if the petition had been granted, they would have had a chair right at the council table with everybody else. Instead, the only way they showed up publicly was by having somebody from their firm sit there and hand questions to the attorney generals out of questions they wanted them to ask of witnesses. So they participated, but they did it surreptitiously. And just a few weeks before the hearing, and this is all in the record, I'm not going outside of the record, they shipped 5,000 pages of documents for use in that proceeding, a roadmap which they thought would assist the attorneys general in presenting a defense of Director Walsh's denial of this license. They didn't like the way the hearing was handled or worse yet, the decision. So now what they've done is they've turned around and trashed the judge for being incompetent, trashed the lawyers from the Attorney General's office as being incompetent and intimidated, as well as trashing Ron and me. These are the same attorneys general who sat here competently in this chair right here for years, Mary DeLatte Williams, counseling and advising you. And they went to such desperate steps of attacking her legal representation in this case. Who has dispassionately reviewed the record? They say, if you don't give Jerry an opportunity to challenge this horrible decision, who will? If not now, when? Well, there are people who have dispassionately reviewed the record and who have not engaged in such histrionics and who have rejected further legal proceedings where they could have challenged the decision. I refer to Judge Douglas, who evaluated things pretty carefully and documented it. I refer to your interim director, who reviewed the record and elected to conclude that he didn't disagree with the decision or the recommendations. I refer to the entire ADOR agency and the entire gambling agency, each of whom are aggrieved parties and who had the right to go to court to challenge the decision and elected not to. They had their opportunity. I'm speaking of Jerry and TP Racing, and they didn't take it because they wanted to save their ammunition for a later day, or they felt sufficiently confident that what happened before Director Walsh would be acceptable. Well, it wasn't acceptable. Director Walsh, the administrative law judge, specifically addressed the ex parte contacts between lawyers for TP Racing and Jerry with Director Walsh. It wasn't just a matter of giving a call or paying a visit and saying, we have some concerns here, we'd like to share them with you. That's not what happened. What happened was that the notice of denial was drafted in material part by Mr. McDonald. He was given a draft by Director Walsh. He participated in the drafting, including that nefarious provision which strips Ron not just of a license, but says because you don't have a license, you can't have any ownership interest in TP Racing in Turf Paradise. Zero. There are a dozen other limited partners there that don't have a license, but not even Ron can have a license because of what McDonald put in, Mr. McDonald put in. And they knew what they were doing was wrong, both the director and Mr. McDonald. Mr. Walsh wrote to Mr. McDonald when he was exchanging these emails and said, keep this to yourself. Keep it to yourself? That's not how this agency does business. Keep it to yourself and then not put anything in the public records? Nothing in the public records? Keep it to yourself. That's what was wrong with what Mr. McDonald did. Not that he paid a visit. He could pay a visit all he wants. It's what happened when he wasn't paying a visit that matters. So what does the law say? This is something that counsel prefers to ignore and instead wants you to review on the dictionary or whatever your gut tells you. We discussed the law at length in our brief. Under the law, one must establish several facts. That their interests would be adversely affected by the agency's decision, their interests, or that they have suffered particularized harm, injury in fact, and damage peculiar to them, and more substantial than the general populace at large. They must show that they were denied some personal or property right, or suffers a substantial burden because of the judgment. There's no question that Jerry and TP Racing are unhappy with the decision. They worked long and hard and spent a lot of money of Turf Paradise that could have been better used by this agency in getting that notice of denial issued in the first place. They're concerned because we have brought to the court's attention the recommendation of the law judge to reverse it and issue Ron a license before the notice of denial was even signed. And when they knew it was going to be issued, they ran into court waving paper in front of the judge saying, look what we've got here, a letter from the director Walsh that he's going to deny the license. Judge, we need an emergency hearing right now to set aside these injunctions that you've issued against Jerry and TP Racing that were designed to protect Ron. Because Ron's going to lose his license, Judge. And now they have the chutzpah, if you will, to come in and say that we are misusing the administrative law judge's decision and the deference to it by the director in telling the judge that something's wrong here and we need to revisit some of these earlier decisions made in the case. It's not fair. Not fair. So let's take a look at their claims of grievance. And in doing so, let's be very clear in answer to questions from the commissioners. To be aggrieved, they must show harm to them personally. From what? Not from Ron Sims, but from the decision and findings of the administrative law judge that Ron is entitled to his license. That is the very narrow and specific framework that we're operating in. It's not about Ron Sims. It's not about me, which they want to do in their brief. It's whether or not the decision of the judge saying Ron's fit for licensure. How have they been harmed from that decision in the record as it stands today? They aren't. They've demonstrated no harm to them personally for Ron Sims to be licensed, either as a non-owner, which they claim him to be, or as an owner, which he's been for many years without incident. They want to reverse that decision because they want to use the poorly and ill-advised notice of denial against Ron in the civil litigation as they have been for the last 2 years. That is not a basis for this appeal, and it's improper for the commission to consider either what they will do or what we will do with a notice of denial or without a notice of denial in the civil proceedings. That's another fight for another day. Your role is very specific and discreet. Do they pass the very high standards, not low standards, not dictionary standards, but the legal standards of establishing that they are aggrieved? Let's talk about what they claim makes them aggrieved. We were accused of fraud, criminal misconduct, conspiracy. Where? Where? Not in the ALJ decision that I've read. Where? They've made it up. They also argue that the administrative law judge found misconduct on Ron's part, and nevertheless blessed it by finding Ron suitable for licensure, and that the misconduct of the judge in finding misconduct acceptable implicates Ador, Jerry, and TP Racing in Ron's misconduct. But that's not what happened. It's the exact opposite of what the administrative law judge found. The administrative law judge found that Ron's conduct was lawful, that it was legitimate, that the transactions involving Ron and Ador and Jerry were valid, that there was no fraud, and that Ron cooperated with Racing, including answering Ador's questions during its limited investigation. This slide that I have up here, 11, makes the point. On the one side, we find the charges made by them in their brief to you. And on the right-hand side, we find the ALJ decision. Jerry's first claim, Ador knowingly participated in a fraud, and that Ron and Jerry submit a phony written promissory note, It was intentionally falsely documented in the public record. The judge found to the contrary. He not only exonerated Ron, he exonerated Jerry, he exonerated racing in the process. He said Ador did have notice that Mr. Sims believed that Ron and Jerry could elect to pay their promissory notes with cash, or rather transfer their respective entities' land to TP back in 2000. Next claim. This is from their brief, all of these. The charade was done to aid in a tax fraud. They accused Ron of engaging in a tax fraud. What did the judge find? No charade and no tax fraud. Quote, Mr. Sims relied on a tax attorney who advised him that the 1031 exchange met the requirements of controlling law and was legal in 2000. The IRS has never challenged the exchange. Next item. Ron refused to answer Ador's questions during a permit investigation. The judge went through each and every one of those questions. There was no finding of Ron improperly refusing to answer any questions. Ron's investigator, quote, got what they asked for. This is an email from your investigator, Verite, to Ms. Cosby, to Director Walsh, saying, we've done the interview, we got all of the answers to the questions we needed. She testified to that not only in an email, but also at her testimony before the administrative law judge. Next item. To grant an individual like Ron Sims an owner's license would undermine public trust and confidence. The judge found to the contrary. He found, quote, Ron Sims is qualified to be licensed by Ador and that he has sufficient good repute and moral character to satisfy the statutory requirement for a license. Why would one brother come in here and argue against the vindication of his brother as being qualified for licensure? Because of the pending litigation, and only that. They claim that Ron is a menace to racing. Because why? He seeks to dissolve Turf Paradise and sell his assets. This is completely out of context, and it is a scare tactic. First of all, it is totally real, even if true, and it's not. It has nothing to do with what you need to concern yourself with. Why? It's not in the record. There's no such charge against Ron in the notice of denial. He was never charged with being a menace to racing. He was never charged with doing anything hostile to racing with relating to any claims he was making in the civil litigation. It's outside of the record. It's outside of any acceptable appeal. And on the facts, they're wrong. Ron does not want to put the track out of business. What Ron seeks in the civil action, and which is of really no concern, should be of no concern to you here, is for Jerry to be removed as a manager because of his misconduct which harmed Ron and harmed racing. The injunctions that were issued and that Mr. Torrey kind of minimizes, they are exhibits to the brief that we filed on this issue. I would invite you to read the court's findings and the injunctions that were issued to protect Ron and TP Racing from Jerry's misconduct. Recall also, as was presented in the ALJ proceedings, that there is a history here of gaming. In previously finding, quote, that Jerry's history of bribery, extortion, and association with organized crime figures is sufficient evidence of Jerry Sims as a gaming services provider would pose a threat to Arizona gaming industry, and the Court of Appeals affirmed those findings. That's in the record, but it is not dispositive to whether or not Jerry is an aggrieved person. Slide 12. This is a portion of the litigation where Jerry's history is identified in the last allegation, and then the next two provisions clarify and put in context what Jerry is asking the court. What Ron is asking the court. Ron is asking the court that based upon Jerry's misconduct, Ron is asking that he be removed and replaced as the manager of the day-to-day operations of Turf Paradise. Only as an alternative to that does he ask that the partnership, not the track, but the partnership be dissolved and its assets sold. Not that anything else happened. And there's nothing in here to suggest that there would be any end of Turf Paradise as a racetrack or of the racing business. With respect to these personal attacks, I only want to refer to one because it's another scare tactic and it's false. They accuse one of Ron's lawyers, me, of having lobbied the governor to strip you of all of your power and authority and disband the Racing Commission. That is not true, and it's also nothing in the record that would be of any concern to you other than an attempt to taint me, and by tainting me, taint my client. The purpose of this attempted appeal is to help Jerry in the civil case. It's as clear as can be. It's a retaliatory move. Jerry has also spent an estimated $5 million of TP monies to deny Ron his license and to force this issue to where it has gone today. It's Jerry who operates on the fringe and uses the TP treasury to fund his vendetta, not Ron. Ron is not draining the funds of TP Racing. And Jerry is now at the risk of losing in the civil court what he gained by holding the notice of denial in his hands. The law requires that you be neutral on this issue. The Arizona Downs versus Turf Paradise case held that as part of the regulatory function of ADOR may not favor or decide in favor of one permittee in order to assist another permittee in litigation or otherwise. That's not your concern, and legitimately so. There are times when abstaining or doing nothing is the right decision. Here, if you have any discretion at all, and I don't believe you do under the law because I believe the law is clear and convincing that they do not have agreed status standing, you should exercise your discretion in deferring to the ALJ decision and the conduct of your own interim director. That was their judgment, and we urge that you follow that guidance. That concludes my statement on agreed person. I do wish to note, just for the record, that we do have a number of motions pending, all of which are probably familiar to you. We have not yet received any hearing date. We've not yet received any procedures or guidance that's going to follow. I do renew my request, or will state it now, that given the fact that you have accepted jurisdiction, unless you are going to deny the appeal for lack of agreed status purposes, then I would ask you to put over any consideration of the merits of the appeal for at least 90 days so that we can have an opportunity to go to court and test whether or not you in fact have jurisdiction. I say that with all respect. I've sat in positions similar to yours on 2 state commissions in my own state of California, and I think you probably all appreciate the fact that this statement is to protect my client's rights. It's not in any way considered to be an attack, and I don't want you to view me as a menace to racing either. Thank you. If there are any questions, I'm happy to answer.
Thank you, Mr. Roseman.
You know, in light of the testimony today, I move that we table this until new business item number 1 at the November meeting. it's my understanding from Cassie that we just got the record last night. It has not been distributed to the commission. And I'd like to read it because it has a bearing on Mr. Torrey's argument that there's all this.
That's the ALJ's decision.
Yeah, this is the record, which we'd have to review. We'd have to review if we were to consider the appeal anyway. So I'd like to table it, but I can tell Mr. Torrey's chomping at the bit back there.
Well, I'd love to respond if you want to hear. If you're done for today, then I can wait. But if you want to hear a little bit more, I'd love a couple more minutes to respond to a couple things.
We didn't permit rebuttal. First one.
Wouldn't we have to turn down them? I made a motion, so do we have to deny the motion to allow more to go on? My motion was to table this to new business item number 1 of next meeting. Give Mr. Grossman and Mr. Torrey or Manning the opportunity to respond at that point. But I'd like to review the record because, as I said, if it's full of all kinds of slanderous stuff, then you'll stipulate that he's an aggrieved person, and if it doesn't, then I'd like to know that before making a decision.
Good.
I'll second the motion.
Discussion?
I'd like to hear some legal advice on where this takes us before I decide whether I vote yes or no.
Okay, well, it's been moved and seconded.
Commissioner Feldmeyer as well.
Thank you. It's been moved and seconded that we table this discussion until the next meeting of the Racing Commission. All in favor?
Aye.
Opposed?
So we're going to table this and not go into executive session first?
I think there was a motion on the floor.
Right.
The motion on the floor.
Yeah, we haven't decided anything other than we'll read the OR report and come back, and then we can go into executive session.
No, it's not order.
I would advise you to go into executive session if you have any questions regarding what.
Should I withdraw my motion? I withdraw my motion.
I would move that we go into executive session for legal advice.
I'll second.
It's been moved and seconded that we go into executive session for legal advice. All in favor?
Aye.
Aye. Opposed? Okay, motion passed.
At 12:29, we're going into executive session. Okay, go ahead.
I think we're going to go back on the record now.
Okay, so we're in the third regular session of the 638th regular racing commission meeting on October 8, 2015, and the time is 12:48.
All right, so we're back to the notice of appeal to the Arizona Racing Commission of the director's ruling to grant a racing license for Ron Sims, and specifically whether Jerry is an aggrieved person or not. So I think we need to come to some conclusion on that.
I think Mr. Torrey wanted to respond. Did you not?
I did, yes.
Do you know which one?
This will.
I thought it was interesting in general. Mr. Grossman made a lot of comments about how we were supposedly making personal attacks on other people, which isn't true. And in fact, most of his brief and most of what he said was simply a personal attack on Jerry. And he talked about the merits of the case, like why it was right that he got a license and how wrong it was what Jerry did and what Mel McDonald did, TP Racing's lawyer, against him. But all that just makes my point. he's sitting there citing to this decision, saying, see, this shows that what Jerry did was wrong. This shows that Jerry's a bad guy. This shows that Jerry conspired against me. And then, my favorite, he even went and cited some Court of Appeals decision from way back when about Jerry not getting a gaming license, as if that has anything to do at all with Jerry being a party aggrieved here. But that makes my point again, because that is the same sort of thing that can happen with this document we have here. We have a decision about a gaming license from a long time ago, and here we are years later. Marshall Grossman is coming into court saying, see, Jerry's a bad guy. This proves it. It's going to be the same thing for Jerry with this ALJ decision, where they're going to take it and say, see, this is proof that Jerry's a bad guy. There is no way he is not aggrieved by this decision. It's also interesting that Mr. Grossman said, well, the ALJ decision really doesn't say that Jerry did anything wrong. And he said it in his brief, and he said it again standing up. But over in court, he just filed papers in summary judgment, and this is what he said. This is a quote from his brief. Judge Douglas did find fault with the ex parte influence exerted on Director Walsh by the lawyers for TP Jerry, but not Jerry. That's what he said here. I'm sorry, I read the wrong one. In court, he said Jerry's undue influence exerted on Ador and Director Walsh, which the ALJ has found did occur. So he's here telling you, saying, hey, the decision doesn't say anything about Jerry. But he's over in court saying it absolutely does. In fact, maybe just ask Mr. Grossman outright. Does the ALJ decision say that Jerry did anything wrong at all, legally, ethically, or otherwise? He's telling the court it did. He's telling you it didn't. But it's plain that this is a statement that's going to be used against Jerry. Mr. Grossman said we ignored Arizona law and Arizona cases. We didn't. I discussed his cases more than he did. The Phoenix, Arizona case, where all you have to do is not like the sight of a billboard, and that's enough to be an aggrieved person. He said you can't look to dictionary definitions. Well, that's not true. The Scenic Arizona case says you can. And it looked to the definition of aggrieved. His other cases deal with a situation where you've got a party in court appealing a judgment to the Court of Appeals. So let's imagine, we were in a car accident, Commissioner McClintock, and I owed you some money. And then somebody else, Commissioner Heupel, wanted to come in and appeal it for some reason. Well, that's what those cases deal with. The Commissioner Heupel he has nothing to do with it. But this is a different situation. As we talked about before, it has to be someone other than the parties, and there is no one closer to this situation than TP Racing. And that's all I have.
All right. Thank you, Mr. Torrey. Does anybody else have anything to add to this?
All right.
I need help. Mr. Sims.
Can I speak as far as being an agreed party? Is that the council doesn't think I can?
Okay.
So I probably should.
No, I don't know. Steve?
Can I just make an observation?
Sure.
And it's...
Make it quick.
Yes, thank you. Steve Nolan, licensee of the racing industry for years. I'm not going to go into legal aggrieved party. The state is an aggrieved party in this. The industry is being hurt. This case started 2015 or 2010. It's this going on with no end in sight has caused the taxpayers now, because the civil has gone into a matter that's costing the taxpayers tremendous amounts of money in legal fees and no end in sight, because now they're entrenched in it for years if it continues. The aggrieved party are our licensees, the state, the people of the state that are footing the bill, And I want you to take that into consideration when you do this. We're the ones hurt. The breed, we talk about breed money, we're hurt. It continue to hurt with no end in sight unless this empaneled commission starts to protect the racing participants and the wagering public. And you can put a stop to it. You are the empowered ones by us, government of the state, who pay the bills, the taxpayers. We're the aggrieved parties here. And continue to be aggrieved. Every commission meeting. And I thank you.
All right, thanks, Steve.
I don't have any questions. I think I've heard everything I need to hear. You want to do it, or you want me to? Go ahead. Feel free to add on. Serious. All right, Mr. Chairman, after hearing what I've heard and the 3 days I spent in preparation for today, I still center the question mark around how has Jerry Sims been aggrieved, and I haven't heard it. I haven't heard it at all. I've heard a lot of putting it kindly, disagreements between one brother and another, but it doesn't have anything to do with one person being aggrieved. The racing industry's still going on. Horses are moving in. We've got another season coming up. That's all good. It's good for the industry. That part is. So with that, Mr. Chairman, and please, with my other members here, feel free to add in if you feel you need to. I would move to deny the request or the appeal, if that's the appropriate language. It's the appeal.
It was filed as
The appeal of the director's decision, which endorsed the administrative law judge's decision.
Based on?
You're going to have to help me because I can't read your mind very well.
Do you want to say something about the person agreed? Or whether or not you... That's the question, is whether or not Jerry's agreed.
Based on what I've read in preparation for today and what I've heard today, I don't feel like he's been aggrieved.
So is that your motion?
That's the motion.
Do we have a second?
This is Commissioner Beret, and based on myself not hearing that any personal or property rights will be denied, I will second Commissioner Feldermeyer's motion.
All right, it's been moved and seconded that we disallow Jerry Sims as an aggrieved person in this instance. All in favor?
Aye.
Aye.
Opposed?
Nay.
Nay. I'll vote nay also. So motion fails. So now.
You have to sit here until you make a decision. You could discuss it again. Have further discussion, further questions. I'm sure the sides would want to say something one way or the other, but there needs to be a decision made.
All right, well, I don't really know what my feeling is. That this is just above my pay grade. I'd like for the courts to decide this and not have this commission decide it. I don't know if anybody else feels the same way or how you guys feel. But,
I firmly agree.
Well, I think Marshall indicated that they were going to special action it to give him 90 days. Is that correct?
That is correct. And I would have a question of you with respect to the scope of your motion. There are 3 potential aggrieved parties here. There is Jerry Sims, who seeks that status. There is TP Racing, who seeks that status. And there is Bell, I believe, the general partner who seeks that status. So if you're going to resolve the totality of the aggrieved person issue, I would suggest for your consideration that you take a vote on the other 2 as well. Otherwise, their seeking aggrieved person status will have not been resolved.
What does Bell do?
Bell forcibly replaced the partnership between Jerry and Ron as the general partner. Bell, as I understand it, is wholly owned by Jerry Sims.
Does it have anything to do with the operations of the track, or you don't know?
You'd have to ask Mr. Torrey that.
Okay.
Just really quickly, I wanted to say that this is a question of your jurisdiction, so you need to decide whether or not you have jurisdiction and whether or not they are a party aggrieved. Then it can be decided by the court. The only way the court can decide it is if you decide that Jerry and TP were parties aggrieved, and then Ron can challenge it to the court and ask them whether that's right or not. That's the only way it goes to the court.
I thought that's what we did.
So maybe y'all can help me and tell me where you feel like he has been.
Well, I think the last motion was valid as to Mr. Jerry Sims individually. I think what Mr. Grossman was indicating is the entities also seek that. I don't know enough about Bell, but I know TP is intimately involved with the track. So, I make a motion that they are an aggrieved party as well. Person, I'm sorry. I'm not the first one that's done that today.
Do we have a second?
Could you repeat the motion?
Yeah, Mr. Grossman indicated that there's 3 parties seeking aggrieved status, so they're all intertwined, and we assumed in Bill's motion that, Jerry, I was thinking on related entities were aggrieved parties, and we decided that we said that Jerry, we have not affirmatively said Jerry's an aggrieved.
If the motion failed, there's no...
So we need
there's
another
no
motion.
decision. You would have to have another motion that states...
Well, since the other failed, I make a motion that Jerry Sims and TP Racing and Bell be given aggrieved status, person status.
I'll second.
Okay, it's been moved and seconded that TP Racing, Jerry Sims, and Bell, whatever Bell is, be given aggrieved person status.
Some discussion?
Please.
Yeah. Help me then, in the future, if someone wants to challenge the director's ultimate decision prior to the time it comes to this body about issuing a license, then anyone in the future can make that challenge, and this commission is going to have to decide that on what basis, because I'm not hearing it, so you have to tell me what is our standard, because I'm not hearing a standard, and we are opening up the door from here on out to go through this from now to eternity. There's got to be a standard. And I'm not hearing it. He doesn't like his brother, and his brother doesn't like him. And that's no standard. That doesn't work. I had a contractor's license here for 25 years because I had my license and someone else came in and got a license. Does that mean I was grieved in some way? Didn't work. Kept issuing licenses. Anyone that wants to have a license ought to be able to come into the state of Arizona, provided they meet the criteria, and be issued a license. So when do we protect people who have existing licenses? Only when they don't meet the criteria.
You make a good point. I'm not sure the answer to that, Bill. And
and I understand. I understand the predicament we're in. I don't particularly like it either. But rest assured that whatever we do, somebody's going to take us to court.
I think that's my point is Marshall's going to take it to court if we find against him, and Mr. Torres is going to take it for a special action. So, you know, it's such a close call in my mind that I'm kind of looking forward to the initial review. To tell you the truth, have a court tell us what's right or what's wrong.
The court's waiting for us to make the decision. That's our job, whether we like it or not. We've been put in that predicament because we volunteered to come here today.
well, yeah, I don't understand. I still don't understand why Ron wants a license to own a racetrack. I mean,
but
I don't understand how that plays into it because we're not privy to what's going on outside of horse racing. There's got to be a reason.
But that's, tell me if I'm wrong, because I think that's a reasonably legitimate question, but I don't think that's our call. Well, I think anybody can walk through the door and fill out an application, and if we can't do that, we might as well shut down another whole section of state government because we don't need it anymore. The ones that have the license just get to keep it until they die.
Yeah, and like I said, I feel like it's a question that I don't feel comfortable making a judgment on. I mean, it's because I don't understand the whole concept of why this is going on. I mean, I'm confused by the fact that Ron wants a license to own a racetrack, but Ron doesn't want to own a racetrack. So there's got to be an ulterior motive. I don't know what it is, and that makes me uncomfortable. I'd rather have them go back into court, explain it to a judge, and let him make the decision on whether.
But they can still do that, but why would you do it under the premise that the other side's been aggrieved? Because I haven't heard it. Unless, tell me what I'm missing.
Well, I don't think you're missing anything. So let me see if I understand the fact that if Jerry's aggrieved, then Ron's side's going to appeal it. If Jerry's not aggrieved, then Jerry's side's going to appeal the decision. Is that correct?
I don't think that's true. I don't think we can appeal it. At least they're arguing we can't appeal it because we're not a party, and only a party can appeal to the court.
Well, that's another reason for me to
makes it more complicated.
Yeah, but it makes me feel like by declaring Jerry an aggrieved person, we're kicking this to the courts who hopefully have a better understanding of how this should be adjudicated than I do.
But that's what the court's expecting us to do.
I know.
We need an executive session.
Well,
If you have questions about what happens in the special action and what the appellate report, the Superior Court has the ability to do.
Please don't do that.
Go into executive.
I can't hear her.
She needs to
Well,
speak into
then
the
ask her to speak into the mic. You're banging on that, and the recorder picks it up, and then we hear it transcribing.
Yes. Okay. If you have questions about what happens in a special action, what the standard of review is, that and in a judicial review action, I'd be happy to go into executive session and explain it to you. It's not a trial. It's
All right.
clearly not a trial.
Would someone please make a motion to go back into the executive session?
So moved.
Second.
All right, it's been moved and seconded that we go back into executive session. All in favor?
Aye.
Opposed?
Okay, it's 1:11 p.m. and we're going back into executive session. Then we're ready to go.
All right, we're ready to go back into session.
Okay, we are going back into the fourth regular session of the 638th Regular Racing Commission meeting of October 8th, 2015. Go ahead.
It was commented on that further discussion was probably warranted, so I withdraw my motion at this time.
Okay, so here are the concerns that we couldn't talk about in the executive session. We need to talk about in open meeting. My concern is that Ron's motive is to force the sale of the track because the racetrack's not the highest and best use of that real estate. And he would like to have that property developed. He'd like to be a partner and be bought out at a higher number than the number or the value of the racetrack. That's why I don't want to potentially end Turf Paradise's ability to have this adjudicated in court. I don't think we know enough, and I know I'm not supposed to speculate on what if, but I don't think we know enough to make a determination to end the process. And I don't even know if we would end the process by finding Jerry not an aggrieved person, or Jerry TP Racing LLC and Bell. So that's my concern, and I'd like to hear other commissioners' feelings on this.
This is Commissioner Beret, and while I do have the same concerns you have, I've yet to today, and stuff that we've read preparing for this meeting, I've yet to be convinced that there would be a personal or property right denied in finding the parties aggrieved in this, and that's where I'm standing at right now.
Okay, anyone else?
Well, Mr. Chairman, I made the motion that went down. I still feel the same way. Although I'll tell you straight up, I share the same concerns that you have expressed. Given that too, though, my background in my business tells me that business stuff changes all the time. Our job today is not to decide what somebody wants to do with their business at some point in the future. We don't want that to happen, but we can't. That's not our job. That's not our job. Our job today is to decide two things. We've done that all. We've done the first one already, and the second one is to decide whether or not the party that made the appeal has been aggrieved. And I'm still waiting to hear that.
I think Chairman McClintock's point was it's been alleged as a threat if they can't get Jerry removed as manager of TP, that they would move to dissolve and sell the assets of the track. If that were to occur, obviously TP would be aggrieved. So it's a close call, and I kind of agree with our chair that, it's such a close call that And when I hear one, it ends the road for one side, if we roll one way, and it doesn't end the road for judicial review for the other side. You know, it's just too close to end the road. I think you guys need to duke it out and have a court decide if we're right or wrong. Go ahead, Marsh.
I would like to just express my appreciation to the attentiveness and the issues that you are dealing with and making them clear to us so that it makes it easier for us to respond. On the point of whether that racetrack would be sold, I have two responses to that, one of which I feel comfortable in giving, one of which I would like to have the ability of a little more time to give. The one that I'm comfortable in giving is that there is no question in my mind but that is not an issue which is relevant to whether or not one is an aggrieved person or not. It's really a recipe for somebody taking a look at a decision to grant aggrieved person status and ask, what were you thinking? What were you doing? Because the test here is whether there's anything in the ALJ decision which affects personal or property rights or interests of a third party in a legal sense, not a business sense, but a legal sense. And even if it's in a business sense, there's nothing in that decision which addresses the sale of the track or the dissolution of the company or anything else. So what they have done here is to reach outside of the four corners of that decision to touch, they've done it skillfully, and I respect that, to touch a nerve here because nobody wants to be presiding over something that would be harmful to the industry or to those involved in the industry. I get that. And that's my response to the first part. My response to the second part is that I know that a sale has always been a last resort, a last consideration of Ron, and that's why it's pleaded in the complaint as it is, tied to Jerry remaining, because Ron feels genuinely that it's not in the best interest of racing. Jerry remaining, because it's not in the best interest of racing as far as Ron's concerned, for the track to remain in existence under the current business structure. But where I'm not able to give a complete answer and where I'd like a little time, if you continue to believe that this is of great importance to you and could be dispositive to your decision making, because this has come up as a serious matter, I didn't take it as such previously, frankly, viewed it only as a scare tactic, but because this has come up as a serious matter, I would like to have some time to meet with Ron and find out from him what assurances he can provide you going forward that he will not attempt to sell the business, or that it would only be attempted to be sold under certain conditions that might be acceptable to you. So I'm willing to have that discussion with Ron. It's not a, let me make a quick telephone call discussion. It's a very fundamental discussion because he would be giving up legal rights, which he has, in order to preserve other legal rights that we believe he has independently of that. But if that is one small step to getting something off your desks and off of your concern, I'd like to take the time to get it done. And I don't mean a lot of time. I mean, I think we can get this resolved, hopefully, internally within a week and report back to you or your counsel as you would like. The point that continues to nag at me, though, and to trouble me, is that counsel couldn't and didn't refer to one thing in the ALJ decision and tether it to the economic interests or business interests of his client. Not one thing. And that, to me, is the test of an aggrieved person. When he stood here and said, they're accusing Jerry of conspiracy, they're accusing Jerry of a fraud, they're accusing him of criminal misconduct, and I said, there's nothing that uses those words in the statement in the ALJ decision, nothing. And then he got up and twisted it all and said, there's obviously material in there that is accusing Jerry of wrongdoing. Well, even if there is, it ain't criminal. No, that word isn't used. The word conspiracy isn't used, and the word fraud isn't used. So I simply close by saying, if this continues to be of a concern with you, let me try to work it out in a way that is legally binding and gives you a comfort level. Because we need finality of that decision. We all need finality of that decision. You all had many opportunities to try to negate finality. Your interim director had those opportunities. Each of the two agencies had those opportunities, many times over. And we did too, in the sense that we could have asked for more as a prevailing party. We've tried to be stand-up guys on this and do the right thing. And I trust you to do the right thing, and if we can be helpful in paving that way, then we'll do it. And if I can't report back in a way to satisfy those concerns, I'll tell you that I can't satisfy your concerns. I appreciate your hearing me out.
Thank you.
May I speak?
Sure.
I'm not eloquent and I'm not a lawyer, but I'm going to be straightforward with you.
Oh, I'm sorry. Would you please identify yourself for the record?
My name is Jerry Sims.
Thank you.
Probably one of the most difficult days of my life to hear the things that have been said here. Everything, and I'm going to address some things that may take me a little longer, but this is an awful important day in my life. Mr. Grossman said, I'm going to be real straight with you. These were not true. He said, I'll give you a small example of how he twists things. He said he didn't go meet with with the governor about getting rid of this commission. It's true, he met with the governor's lawyer, Mike Larrabee. And he can't tell you he didn't. He went and met with Mike Larrabee about getting rid of this commission, but he makes it sound like he didn't do it.
I'd like some proof of that.
That doesn't make any difference. He's going to get to the legal issues, and I'm going to tell you it happened. He stands here and says that decision from the ALJ doesn't have the word fraud in it. It doesn't. But I'm so aggrieved by what they did is my lawyers weren't a party to that. And the material, there was nothing presented to, when Ron Sims said in that he had a side deal with the Department of Racing, the ALJ, because there was nothing to dispute it, said we find Ron credible. But there was side deal. Side deal, if I have a deal on napkins, I've got to turn it into these folks. If I did any of the things wrong that he said I did, they should walk right up to Mr. Casillas, to our director, and say these things, and they get me removed. They get me removed. You don't see him going to Rudy Casillas and saying these things. Mr. Casillas knows me very well. He was my investigator when I put in for a gaming license 16 years ago. And if he thought I did what he said I did and took money, they would go right over to our director and report me, and I wouldn't have a license. But he stands here, and it feels like knives going through me to hear these distortions and distruth. Now he says that we could live together with this track. I'll promise you There's no possible way this body is going to take any more. I'm just not. I can't go through this anymore to hear these lies and distortions. If I'm not an aggrieved party with what they've said in our papers and the other papers that they filed and reported to our judges, that doesn't bring you into the civil. I'm just saying it's in the record. Do you know that right now, I'm going to tell you something. We're showing the digest, the one that's for the racing industry, the green label, the magazine they put out, that the articles they wrote about me 15 years ago are not true. And Buzz Alston is getting the paperwork, and I've talked to the gentleman at the Blood Horse magazine. I've never lost my license, as was reported in that magazine. You know how it feels when everyone goes on the internet now and they see that you lost your license? It was taken away from me. It never happened. It didn't happen. If so, where did I ever reapply? It didn't happen. So they're willing to take that out of the magazine, out of the article. It's the only way you can get something off the internet. Everyone, when you meet someone now, they look them up on the internet. Oh, it says my license was revoked. What kind of person am I? So when you have him, that man right there, going and saying to our courts and in the papers, no, it doesn't say the word fraud, but if you heard all the testimony in that OA hearing, these two gentlemen, the Torrey brothers, alternated and sat in the audience for weeks as they put on testimony. There was no one to say that the side deal is legal, that you can have a side deal. If I had a side deal in the papers I turned in that said, I'm buying this track and this is how I'm doing it, we didn't know it. We had no idea. When we found out in 2011 or whatever that was, we came forward. But to have the administrative law judge say that it's okay, that Ron's credible, that he had a side deal, and the papers you turn in aren't truthful, and the note's not the note, and so on. So, thank you for allowing me to go on, but I will tell you, there's no way that what Ron says in a week means anything, because they'll have anything can change it. No matter how binding he wants to make it, I won't. I'm not going to live anymore where he's just trying to get more out of me in order to make my life miserable, so I'll pay him more. I'm not going to do it. I'm just not going to do it. I'm not going to live under those circumstances. It's unreasonable. I can't have these lies told me and have knives go through. It's what it feels like when someone says you stole $2 million. I didn't steal any money. When we were short of money at the business, I didn't take a salary, not 5 cents, for over 4 years. And then everyone said, gee, you should be taking your salary back now. And I took my back salary. There was no injunction. There was no any nonsense like that to stop me from anything. But the man stands up here like it's truthful and it's going to go into a public record that I stole money. Not truthful. If he could have found one nickel that I ever took, he tried. They took every document we had and every crate we had of boxes of our records. If they found one nickel, they'd have been in our court and got me out of there. What he didn't understand is when I brought my brother and 3 of my best friends at the time in that deal, I wanted them to make money. I wouldn't take 5 cents. Do you know, I'm drying them out, so I'm almost done. I wrote a check for $655,000. No one asked me to, and gave it back to Turf Paradise because I didn't think they should pay my legal fees back when I had license troubles. No one asked me for that. I wrote a check for $655,000 to pay back the company because I didn't think that my brother, at that time how I felt about him, and my 3 friends should bear any of that expense. And I wrote that check, let alone that I ever took anything. I gave that money. So to stand here and hear that man stand up here and make these lies to everything and then say, well, he'll talk in a week and see how Ron feels about it. Like, I'm not bereaved. I'm not grieved in this thing. It's not damaging to me. And that Ron's going to say, he won't sell the track. Well, I will sell the track. I will get rid of that track because I will no longer want this in my life and this guy standing up here and lying. Anyway, thank you for taking the time to hear me. Thank you for today. If anyone's not damaged, I want to know who's not damaged. If I'm not, me and Turf Paradise,
while you're there,
Bell is our general partner. Yes.
While you're there, Can you just give me the top 3 reasons why you're aggrieved?
Yes.
Under the criteria we talked about today.
I have to think.
I'll answer.
No. He's got the lectern. I want to hear him.
This is counsel.
I'm his lawyer.
No, I understand that, but I kind of feel like he opened up the
I can
door.
give you a list of more than 3, I promise you. This is tearing up this track, it's tearing up the business, it's the reputation, everything that they're saying about me. It doesn't matter where they're saying it in the civil court, so it's in the record. All the things they're saying about me, if I'm not damaged by him being in this, I can't imagine how anybody could be more damaged. Would you give me? I would join them out.
No, I understand. First of all, I think we need to remember that the standard, I've heard a couple people mention that the standard is you have to show a personal or damage to a personal or property right. That's not right. I mean, think about Ron's case dealing with a person aggrieved, where the damage was someone driving along the I-17 freeway might not like looking at a billboard. The court found that was sufficient damage. That's not an economic damage. That's someone not looking like I think we can all agree that nobody drives along the I-17 freeway because it's a thing of beauty. And the idea that their view of the 17 could be somehow tainted, that's enough to be a person aggrieved. That's our standard. That isn't a case. It's in his case. And again, Jerry has been aggrieved in many ways. I'm not going to go through them all again because we've been through them before. But if nothing else, we've got a decision right now that's saying that, it doesn't use the word fraud, it doesn't use the word conspiracy, but he's in court saying that this is proof that Jerry did bad things. Any one of you up there, if that very same decision said Commissioner Heifel, Commissioner McClintock, Commissioner Wallace, Commissioner Feldmeyer, Commissioner Gorey, you guys conspired to cause Ron to lose his license. If it said that, and it was in there and it's the public record, anyone can go see it, and then people like Mr. Grossman years from now can quote it back and say, see, it's a finding. You don't think that's aggrieving to someone? You don't think that would be aggrieving to you? You think that's less aggrieving than driving down the 17 and there was a billboard there before, but now it's an electric billboard, and so that messes up your aesthetics? That's really bad. But having a public document saying you're corrupt and you did bad things, that's not? Come on. On top of the fact that this is our TP racing business, this is a partner. Believe me, if you read the appeal, if you actually read the appeal we filed, and see what Ron Sims said, what Ron Sims did, and you're still going to give him a license, if that's the standard, then there might as well not be any more standard. Because it's essentially saying that you don't have to answer the department's questions, you can lie to the department on important issues, and you can still get a license. And we're supposed to run a business in that environment. And people are going to look at us and say, oh, okay, well, gosh, their owners must have no credibility because, goodness gracious, it doesn't take much to get a license. This isn't even a close call, frankly, and especially when you compare it to scenic Arizona. So, thank you.
I guess I have a question for Director Casillas. Was Ron investigated before he was issued the license by the ALJ, or was this just a hearing?
No, issued the license. Yeah.
Well,
Which instance are you talking about? The most current?
Right.
Yes, he was.
Okay.
If I understand it right on the license, Ron, the license that we're here to appeal is a different license than Ron put in a second application to get another racing license of the same type. Got 2 applications in. So when he was found administratively complete, Director Casillas, I'm not sure, I want to make sure I'm right. The 2 separate licenses in, so you get one, and I saw the letter that the director said, well, you're only getting this temporary license to of his hearing goes, because when I heard they put him for a separate license, that's so they could stand up here and say, we've got a license. That's just a temporary, waiting to see how this proceeding goes, but allowed Mr. Grossman to stand up here and mislead you into thinking that they'd given him a regular license to own a racetrack.
I think we understood, Mr. Sims, that it was a conditional license.
And temporary, but they put in for two. When we heard about it, we thought, what do they mean? We've got a license in that's on appeal, puts in another application for another license. We didn't understand it until we hear how they utilized it.
All right, any discussion now? Do we have a motion?
I'd reinstate my motion to grant Jerry Sims and the related entities, TP and Bell, aggrieved person status.
And I will second it again.
Okay, it's been moved and seconded to grant Jerry Sims, TP Racing, and Bell LLC aggrieved person status. Any discussion about that?
I'll just leave it with, I'm still waiting for the answer to my question. I haven't seen anything substantial that indicates he's been aggrieved under the legal advice that we've received.
All right, so we're going to take a vote. All in favor?
Aye.
Aye.
Opposed? No.
Aye.
I'm sorry, Mr. Gray, could you please clarify, was that a yes or a no?
No.
Okay.
Okay, the motion passes 3-2. This is tough, and it's, what I really care about is furthering racing in Arizona and actually improving racing in Arizona. I wish there was a way to put all the differences behind this, because it just seems like this is one big messed up family that nobody gets along with anybody. So that's my editorial for today. Let's all be friends.
And I'd like to applaud the council today, who I thought both sides did a great job.
Mr. Chairman, may I ask a procedural? May I first thank you?
Sure.
And ask a procedural question?
Absolutely.
Thank you. I'm not going to re-argue the motions. They were fully argued.
We will need some time to prepare a special action or other appropriate action to test the decisions made here today. There's no rush or hurry to resolve the merits of this, obviously, and the record, as you know, is exhaustive. I would ask that there be no proceedings with respect to the merits until at least January, to give us the opportunity of preparing it and the court the opportunity of considering it and hearing it. And we're cognizant of the fact that there are a lot of national holidays between now and the end of the year. I would also remind the commissioners that we have a number of motions on file where we have not had any response from the commission itself or its representatives. And they are, I'll just briefly summarize them. Number one is the request for disclosure of ex parte communications in accordance with the Attorney General Model Rule on ex parte communications. Number two is for the dismissal of the purported appeal and recusal of commissioners based on any ex parte communications that may be revealed, and the absence of any rules, standards, or guidelines for the conduct of any appeal such as this. Number three is new, and it is a request for dismissal based on violations of the open meeting law as set forth in prior filings with the commission and correspondence with your counsel. And number 4 is the violation of our rights to obtain meetings of the closed session where the discussion and apparent vote, now clarified, but it appeared to be an apparent vote, to take jurisdiction occurred previously. So there are those motions still pending, and we'd like to have some understanding of how the commission intends to deal with them. Obviously, it doesn't have to be now because probably very few people are prepared to address them, but we'd like that as soon as possible. Thank you.
Okay. So do we need a motion to give them until January to prepare?
I would move that this be placed on the January agenda for consideration.
Should it be a special meeting versus have everyone sitting here?
That's probably not a bad call. Why don't you make the motion to be a special?
I make a motion that we approve a special meeting in January to hear
the appeal.
Mr. Grossman's appeal.
No, it's Mr. Sims' appeal.
Mm-hmm.
It's
Mr. Sims' appeal.
It's Mr. Jerry Sims' appeal. But before I think any such hearing date can be set, there should be shared what the rules, standards, guidelines are going to be in any such hearing. I doubt that it will take one day. And also, I would ask that whatever is directed in terms of procedures should be put in writing so that everybody's playing on an even playing field and we know what the rules of the road are. Because I do not really wish to show up on a day in January and not know what is going to happen. It would be inconsistent with fair process and due process for that to happen.
Fair enough.
I also recommend that the issues that Mr. Grossman articulated be resolved probably within a recommendation, unless you want
to. I will second Commissioner Heupel's motion to call a special meeting in January. Dates to be determined.
All in favor?
Aye.
Opposed? Good. Motion passes. So,
Mr. Chairman?
yes.
Commissioner Murray, I have a previous meeting that I need to get to, so I've requested permission to be able to drop off from the meeting.
Absolutely. Thanks for putting up with all this, everything that's going on, Roy. Get out and get some fresh air. See ya. Can we move on to item 2? Or do I need?
You might want to address the procedural issues that Mr. Grossman articulated regarding the ex parte communications and so forth. You can address some of those now, or you could address them at the November meeting.
I haven't seen those motions. Are they're in written motions?
Yes, the first two are. Was the third and fourth? Are they new? Let me just verify
Did we?
I got a motion to any emails or telephone conference.
I haven't heard.
We could decide them in November.
Yeah, let's
Basically, the rules. Or in January.
The motions filed previously did not include the request for dismissal based upon the open meeting law and the denial of records under cover of the what's it called, the in-camera meeting. The
Executive session.
Oh.
Executive session.
Correct. Other than that, I believe the other motions are on file in writing.
Okay.
I don't want to drag this out any longer than it needs to be, but I'm not familiar with those motions. Number two, I'm not sure, this being an administrative body, that there's even a procedural mechanism for motions. So I'm not sure why we're hearing motions, but if we're going to hear motions at some point, we're going to want a chance to respond to those. But again, I'm not sure, there isn't even any rule that allows for motions.
We're going to address those concerns.
Okay.
And it'll be all just somebody.
I move we put the decision on Mr. Grossman's motions set for the January agenda. I'm sorry, November agenda.
We have a second?
A second.
Thank you. Okay, it's been moved and seconded that we just have ready the procedural motions in November. I think that's what I'm trying to say. All in favor?
Aye.
Aye. Opposed?
Nay. I think we'll, at that same time, your question will be relevant as to what the procedure is, because we don't know.
Okay, so at this point, we shouldn't respond to these. We'll find out in November what's going to happen. Then we can respond after that if we need to.
Right.
Okay. Thank you.
Let's move on to item number 2. Request for temporary permits and live racing dates at county fairs. A, Greenlee County Fair request for a temporary permit for live racing dates April 9th and 10th. Do we have anybody from Greenlee County? Personally, I'm all in favor of this, so do we have a motion to approve the Greenlee County request?
So moved.
Second.
Okay, it's been moved and seconded that we grant Greenlee County Fair a temporary permit for live racing dates April 9th and 10th, 2016. All in favor?
Aye.
Opposed? Passes. Item B, Graham County Fair request for temporary permit and live race dates April 23rd and 24th, 2016. Do we have a motion?
So moved.
Second. All in favor?
Aye.
Opposed? Motion passes. Request for Cochise County. This is item number 3. Cochise County Fair live race dates. Cochise County Fair request for live race dates May 21st and 22nd, 2016. Any discussion, or do we have a motion?
So moved.
Second. Okay. It's been moved and seconded that we, let's, all in favor?
Aye.
Aye. Opposed? Motion passes. We have item 4, Turf Paradise requests approval of 2 new off-track betting facilities. One's at Colby's Corner, 3101 East University Drive, Suite 12, Tempe, Arizona. Any discussions? Anyone here?
Rudy, is there everything in order in their application?
Yes, sir.
Okay. I move we approve Colby's Corner.
Second.
All in favor?
Aye.
Opposed? Motion carries. And item B, off-track betting facility at Dos Gringos Mexican Grill, 8000 South Priest Drive in Tempe. Any comments or discussion?
I vote to approve.
Second.
Been moved and seconded. All in favor?
Aye.
Opposed? Motion carries. All right, do we have a report from American Greyhound Racing?
That's the report this month, Mr. Chairman.
Thank you. The county fairs. So
It's just business. Good afternoon. I really did have good morning on my notes, but good afternoon. Take it as you will. Thanks very much for your very prompt approval of our Cochise County Fair Days and for Greenlee and for Safford and Graham County. We are excited to be able to move forward with our organizational work that will provide the structure for our 2016 County Fair Racing Circuit in Southern Arizona. In my remarks to the Commission at the September meeting, I mentioned the ACRA and El Moro de Compas Foundation would be providing you with additional information regarding the nature of our working relationship and the role that we each have in the task of building a solid foundation for each of these county racing events. At the summer ACRA meeting in Safford, the El Moro Foundation and Arizona Counties Racing Association agreed upon a resolution to collaborate on the development, the promotion, and the sustainability of El Moro Compas horse racing activities at designated participating county fair tracks. The opportunities to deliver the El Moro de Compas horse racing events at these same tracks has allowed us to recognize the importance of integrating resources and funding. We've had a wonderful eye-opening experience in these last 6 or 7, 8 months now of recognizing the value of this partnership and this collaboration. As a result of these statements of intent, the Arizona Counties Racing Association has agreed to recognize the El Moro Foundation as a stakeholder organization for the purpose of planning the above-mentioned 2016 County Fair horse racing meets. And as a result, I invited them to be a part of this meeting today, and I'm sure it's a meeting they'll not ever forget. So the President, Vice President, and Executive Director of the El Moro de Compas Foundation are with us this afternoon, to provide you with a quick and concise description of their role as a collaborating partner with ACRA. We are also pleased to announce that Jim Collins, who maybe some of you may remember from years of county fair racing with us, Jim said pretty close to 20 years, county fairs and at Rieto, has agreed to join us and has just recently agreed to handle the duties of racing secretary for the county fair tracks, of which we are about to embark upon now that you have so graciously taken care of your business with us. Jim was a very important part of county fair racing for a number of years in Arizona, and we're delighted to have a professional of his extensive experience working with us on this new project. That's what my personal ACR notes are to you. Do you have any questions? Anything that you would like to ask? Let me just introduce these folks to you.
Sure.
Joanne De Filippo is the Executive Director, and all these folks in Tucson. The Ramirez brothers, Geronimo and Gabriel Ramirez, and just in passing, we're so excited about this because the El Moro de Compas, for those of you who live in northern Arizona, we call northern Arizona anything north of Tucson, you may not be aware of the wonderful legendary history that's attached to that race. But these gentlemen, the Ramirez family, who are originally from El Fria, just a little north of Douglas, their family was an integral part of the original race that was run in 1957. At some point in time, we'd love to tell you all about that.
Well, we're thrilled that you guys are getting fair racing back in Arizona, and we'd love for every county to have fair racing. So thank you very much for
all
your hard work.
Thank you so much.
Rieto.
Good afternoon, Jay Wells, President of Rieto Park Foundation and Rieto Racing. Before I get started on my Rieto comments, I just wanted to say to you guys, and you said you're above your pay grade. I know what your pay is. You didn't earn a lot of money today, but you earned a lot of respect. I appreciate your hard work on that. It's important. Who thunk it? Rito's doing well. We're in the final stages of negotiation for a long-term contract with the county. We're going to apply for our dates starting for your November meeting. We'll submit those to the department this week. The county has them already, and we're debating whether we're going to be able to have a full October meet, which the plan is to actually run 3 weekends before Turf Paradise opens next year. So based on whether that decision goes through the county or not will determine how many days we run in the winter meet. Things are on go. We've already had staff meetings, fundraising, etc. We're excited about it. We would ask your patience. This county issue has drug us beyond where we thought we would, but it's complicated with a lot of different departments. And I will not try to hide the fact that there's a lot of blowback from some parts of the county. But this is understandable. Rito's been in limbo for so long, and they've always just given him a year-by-year lease, and we're insisting on a 5-year lease. And that, of course, as any businessman knows, gives you the right to do planning, logistics, raise long-term financing, etc. So we're excited about the progress. The county motions should be coming up, and they're tentatively scheduled for their vote the first session in November. So we shall hopefully have some really good news for you then. We will be submitting the dates for your review and request a vote on that in early November. But other than that, gentlemen, thank you very much. Any questions?
No, we're just glad to see horse racing in southern Arizona is moving in the right direction.
Sounds like it is.
You don't have a brother that's part of Rito, do you?
You do.
I said you don't, do you?
No.
Oh, good.
I just got it.
Tucson Greyhound Park.
Thank you.
Turf Paradise.
I'll be really quick.
Thanks.
Vince Francie, our General Manager of Turf Paradise. We're ready to open in 9 days.
Perfect.
Good.
All right, Optional Industry Stakeholder Association updates. Arizona Greyhound Association. Nothing to report. Arizona Quarter Racing Association. Nothing to report. Arizona Thoroughbred Breeders Association. I didn't skip you this time, Kevin.
Oh, you remembered.
Yeah.
Thanks. No, nothing to report this time.
Thanks, Doug. HBPA, I think they got tired too. And the Jockeys Guild, I know they're not here. All right, summary of current events affecting the Arizona Racing Commission. I could take another 3 hours. I guess we'll skip that. And are there any matters to be placed on future agendas? Bill, I know you want an updated safety report. Is there anything to report right now, Director Casillas, as far as track safety reports?
Not necessarily. We're still working with TGP and TURP on some of the previously identified issues of concern. They're working with the department's agents that are assigned to the field, and there's some progress being made. There's a few things that are still in progress. So next month we'll have a better report to provide the commission.
Great, thank you. Does anybody have a matter that needs to be placed on future agendas?
I think we know.
All right, yeah, I think we have too. We've the call to the public, and I think Joanne, would you like to say something, or just to?
I have something to read to you.
Absolutely, please.
I was going to start out good morning, too. However, I will transition to good afternoon. I'm Joanne DeFilippo, and I am the Executive Director of the El Moro Foundation. And thank you very much, Chairman, Commissioners, and Director Casillas. I actually have, I'm not sure if you received it this morning, but the City of Douglas forwarded a letter to the Arizona Department of Racing this morning, and it's on behalf of the City Manager, Carlos de la Torre, and he wanted me to read this to you. It's addressed to all of you. On behalf of the City of Douglas, our City Council, staff, and residents, we welcome the return of the El Moro de Cumpas horse race to Douglas, Arizona. Much of our region's cultural heritage is grounded in relations found on both sides of the border. The El Morro de Cumpas is an excellent example of how two communities from two different countries can work together to share in the cultural heritage of its people, places, and history. For the city of Douglas, the El Morro de Cumpas represents more than just a horse race. Arizona's rural communities have suffered greatly with slowing economies and diminishing resources. We view the return of the El Morro to Arizona's rural communities as not just a sporting event, but an economic development opportunity from which our local and regional businesses can profit while participating in the El Morro festivities. It has been over 5 years since we last saw horse racing in Arizona's rural communities. For many families and spectators, the races represented a time when families came together, communities shared resources. Oh my God, I have a call coming in. It's your wife. So I'm declining it, okay? Communities shared resources and tourism increased in the region. When the races stopped after 2010, we lost those opportunities. By approving our race dates, you signified your support to rural communities and bringing horse racing back to Arizona counties. The City of Douglas, through my office, is excited about the opportunity of partnering with the Cochise County Fair Association, the Arizona Counties Racing Association, the El Morro Foundation, the Southern Arizona Horse Racing Association, and our partner track government officials in Duncan and Safford and race associations in Sonoyta and Douglas. We thank you for your support and look forward to an exciting 2016 El Morro de Cumpas Horse Race Festival and the return of county horse racing. And it's signed Carlos de la Torre, City Manager, City of Douglas. And to that, I want to add, we've been working really hard with all of the communities, all the tracks. And actually what we did, the way we got this going again, is we turned it into an economic development project. Many of you know that I bring money into the state of Arizona, and we use that same model of the public-private partnership. We have a model that says everyone is welcome to the table, but you need to bring a resource. And that's how we operate. The way we were successful in doing this is we bifurcated the expenses from the general operating, which we gave that responsibility to the counties and or the nonprofits who owners of the tracks, such as Sonoyta and Douglas. Graham and Greenlee, their tracks are owned by their counties, their governments. We worked with them in looking at all of their financial, I did a financial analysis on a 5-year look at what they did since about 2005 to 2010. We met with all the Board of Supervisors and to show them how we can reconfigure, get racing back on. Then what we did is we restructured purses and racing in the sense that everyone who races, you pay into the race. It's very simple. Many of us in the quarter horse, that's what we have to do anyways right now. It is a little bit different for some of the thoroughbred, but they're agreeable and they've come to the table in this. So we do have sponsorships. We have some very large purses, $50,000 to $100,000, and that's in combination with our national and international sponsors. We thank you today because now we can go ahead and sign those contracts with them. Just to let you know, Globe contacted me this past week. I will be meeting with them, and they want to get on board also, their Board of Supervisors. So through this public-private partnership, bifurcating all of the expenses and breaking everything down, what it did is it took that tremendous burden off of those track owners, be it the government or the nonprofit. And by taking it into smaller pieces, they could actually see how this is something that could be achieved. We also, to let you know, we have initiated an economic development corridor that is now running from Globe, Duncan, Safford, Sonoyta, and Douglas, and it's part of a federal program it's called We're Ready, R-E-D-I, and it is Racing for Economic Development Initiative. We've already received some of our first grants, and that's allowing us to do an entire oral history and filmmaking project. So a lot of that has an academic spin onto it also. And we want to thank you so much for your support.
Well, thank you. You guys are doing a great job, and we wish you the utmost success. So I hope this works out. Geronimo Ramirez. Is it Geronimo or Geronimo?
Geronimo, but
Geronimo. In Kentucky, it's Geronimo.
No, it's a race that me and my brother started about 10 years ago, and it comes from our background. We've always raced, especially in southern Arizona, all along the border. And it's a lot of family heritage and things, but it's also, like Joanne said, a chance for our communities to develop, and the counties. When we lost racing 5 years ago, it was a big blow. And this is where all the families get together, it was a big social event, And so we're happy that we're bringing it back, and it hopes it brings, and we're not here with our hands open. We're here to help ourselves, okay? So, we really appreciate the days. We can get moving with our sponsors now, so thank you very much for giving us the days.
Thank you for getting things going. Steve?
Nothing right now.
Thank you.
Thank you.
All right. I guess I hate to adjourn this meeting. It's been so much fun. But
I think you need a motion.
Need a motion?
I move we adjourn.
You don't really need it.
Oh, you don't? Oh, adjourn.
Just take a walking vote.
Really? Thanks, everybody, for coming.
Thus concludes this meeting. Time now is 2:23.